think that's Manuel making. Good evening, everyone. I'm going to call the regular City Council and Authorities Concurrent Special Stadium Authority meeting to order. Could you please stand for the Pledge of Allegiance and remain standing for our statement of values? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
As we gather, we humbly seek blessings upon this meeting. May we act with strength, courage, and will to perform our obligations and duties to our people with justice to all. Let us seek wisdom so that we may act in the best interest of our people, our neighbors, and our country. All this we ask so we may serve our community with fairness and respect, putting their needs before all.
Thank you. Please be seated. Roll call, City Clerk.
Councilmember and Board Member Mahan. Councilmember and Board Member Hardy.
Present.
Councilmember and Board Member O'Neill.
Present.
Councilmember and Board Member Davis. Councilmember and Board Member Watanabe. Councilmember and Board Member Shahal.
Here.
Mayor and Chair Gilmore.
Here.
Thank you. May I read the AB 23 announcement?
Yes, please.
Members of the Santa Clara Stadium Authority, Sports and Open Space Authority, and Housing Authority are entitled to receive $30 for each attended meeting. Statement of Behavioral Standards. The City of Santa Clara has adopted a code of ethics and values and behavioral standards for public meetings to promote and maintain the highest levels of conduct. This includes mutual respect, robust discussion, and allowing city business to be done in an efficient and consistent manner. Please note that as presiding officer, the mayor's direction in matters of process and decorum should be followed, and that use of the gavel indicates all conversations must conclude and everyone in attendance should come to order and attention. Welcome and thank you for your participation.
Thank you, Assistant City Clerk. Next, we have reports of actions taken in closed session. City Attorney, Stadium Authority Attorney.
Yes, Madam Mayor, the Stadium Authority Board in closed session on a 6-0 vote authorized the initiation of legal proceedings to terminate the stadium management agreement. The termination will only be as of non-NFL events. It will not affect the NFL events at the stadium.
Okay. No other matters in closed session? That was it?
No other matters to report.
Thank you. All right, we're going to move to continuances and exceptions, and I'd like to ask the council/board to move up items 2A, B, and C immediately after the consent calendar. Could I please have a motion for that?
So moved. Second.
Motion second. Any discussion from the board, council, or the public on that? Okay, seeing none, we have a motion and a second to move up those two items immediately after the consent calendar. Please register your vote. And that passes unanimously of those present. Next, we have the consent calendar. All items, are there any other continuances or exceptions from the council or the board or the public or the staff? Any other items? Okay, seeing none, we'll move on to the consent calendar. All items are approved with one motion unless a member of the board, council would like to pull an item, staff, or any member of the public. Would anyone like to pull any items from the consent calendar for discussion? Okay, seeing none, there's a motion for the consent calendar in a second. There's no other discussion. Please register your vote. And that passes unanimously of those present. Thank you. So now we're going to move to item 2A, which is the informational report on litigation matters between the City Stadium Authority and the 49ers and third-party litigation matters arising from the stadium. Is this you, City Attorney, Stadium Authority Attorney?
Yes, thank you. First, I would like to, how does this work? Just do a little brief overview for the public of how the Stadium Authority operates the stadium. The City of Santa Clara owns the land under the stadium. It is supposed to receive ground rent for the land from the Stadium Authority, and the ground rent is supposed to cover the fair market value of that land for the duration of the lease. The Stadium Authority, in turn, leases the stadium itself to Stadco for the NFL season, and it also leases the stadium to the 49er football company. And then the 49ers currently manage the stadium under a management agreement. So the first case I want to talk about these are the three cases that were filed by the 49ers against the Stadium Authority. In my report to the board, I indicate that although oftentimes the press will report that there is some kind of tiff or feud going on between the city and the Stadium Authority and the stadium manager of the 49ers, these are all litigations that were filed by the 49ers against either the Stadium Authority or the city. The city has, at this point, never initiated a lawsuit against the stadium managers, the 49ers. So these are all the current lawsuits. The first one is the 49ers Stadium Company et al. Versus the Santa Clara Stadium Authority. This is known as the declaratory relief case. And for the past 2.5 years, we have been seeking the Stadium Authority's own financial records. The 49ers say they will give us the records, but we'll have to pay for them to get them in order. We'll have to pay for them to get them in order for us. We refuse to pay them to cook the books before they turn the records over. The second case is about the public safety cap arbitration. This is a case that's not in court, it's in arbitration. There's a provision in the lease which caps the amount of public safety costs that the 49ers have to pay for NFL games at $170,000, an amount that was set in 2009. After the costs reach that amount of $170,000, the excess costs are supposed to be paid by non-NFL revenue, and can reduce the performance rent to the city. The Stadium Authority is allowed to dispute the cap after 3 years. The 49ers have refused to consider the Stadium Authority's proposals and are suing us for the amount in excess of the cap for year 4, which is approximately $660,000. The third case is 49er Stadium Company, again, versus Santa Clara Stadium Authority, and that's about the shared stadium expenses. So after it became clear that the 49ers were not contracting for Stadium Authority work in compliance with public procurement laws, such as the prevailing wage law and conflict of interest rules, the Stadium Authority stopped paying those portions of shared expenses as to which the 49ers would not give us documentation of compliance. Instead of giving us the records, the 49ers paid themselves the expenses out of a revolving loan, which the Stadium Authority is disputing this. That and some other issues are the subject of this arbitration as well. And the last currently filed case is 49ers Stadium Company versus the City of Santa Clara, and this is a dispute over payments under the golf course parking agreement. The 49ers agreed to rent parking on the city's golf course after they decided that it was a bad deal. After they decided it was a bad deal, they sued the city to get back the money they paid us for the first several years. The city refused and countersued for the last several months, which the 49ers have now refused to pay. At this point, I feel that a report on these cases is just the tip of the iceberg. As you will hear in just a few minutes, the 49ers' performance of the management of Levi's Stadium has fallen off a cliff, resulting in a wipeout of $2.5 million in anticipated performance rent to be paid to the city. The city will get no performance rent this year from the Stadium Authority, even though it was a necessary element of the fair market value for use of the city's land to build Levi's Stadium. The loss of performance rent is indicative of not just poor performance by the 49ers of non-NFL events. It results from booking money-losing events that have no economic benefit to the city. Whenever we ask why the 49ers book these events, we receive nonsensical answers like, it's a holistic approach. Well, I, for one, don't believe it and have said so to them. I have said that it appears that they are booking these events where the public entities will lose revenue because the 49ers will make money anyway. In fact, when I said this to one 49er executive, she responded, you have the best deal in the NFL. If that's true, I pity the other cities with NFL stadiums. We have further evidence of self-dealing in the form of the admissions made by the 49ers General Counsel in her letter that has been referred to the Fair Political Practices Commission, which the FPPC is still actively investigating for violations of state conflict of interest laws. And then we have 5 years of noncompliance with state prevailing wage law, with still untold amounts of wages not paid to the workers who are paid by the Stadium Authority to work on projects at Levi Stadium. Despite the fact that the 49ers campaign to approve the stadium included hundreds of lawn signs that said, yes on J for jobs, apparently they meant jobs that pay substandard wages. Fellow residents, we are now looking at 2 years in a row that the city will not receive even a penny of performance rent. 2 years of not receiving the minimum fair market value for the land that the stadium sits on. 5 years of refusals to provide the Stadium Authority with its own financial records. 4 lawsuits seeking even more money from the city. Attacks on your duly elected officials who are only trying to get to the bottom of this absolutely abysmal financial performance. We have hit rock bottom. We have nothing to lose by ending the 49ers' stranglehold on the management of publicly owned Levi's Stadium. No doubt that after the Stadium Board's actions tonight, the 49ers will attack me personally and continue their personal attacks on the city manager and the mayor and council. Please remember that these attacks are simply a deflection from their own failures and betrayal of the promises that the 49ers made to you, the voters, getting you to approve Measure J. No matter what may come from these out-of-town billionaires who apparently don't give a darn about the community that gave them their home field, I will not stand down as your city attorney. I will stand for you as long as it takes to get this straight. You work too hard to keep Santa Clara the wonderful city it is for me to do anything less. Thank you.
Thank you very much for that, City Attorney. I think that just about says it all. We appreciate it, especially the fact that we have not filed any of these litigations, unlike what the press continues to report. Is there any member of the council that has questions or comments on this report? Anyone? After the third report?
Okay, so
So are we taking all three together, and then we can go to the public with all three? Okay, I don't see questions from the council, so let's move on to B, which is introduction of an ordinance, and we're going to take A, B, and C together. Introduction of an ordinance to amend sections 17.30, .080, 17.30, is that correct?
yes, it's just a lot.
Do you not want me to say the numbers?
Sure, please do.
Okay, I just want to get them in the record so it's clear. 17.30.090 and 17.30.120, modifying the Stadium Authority Executive Director's authority to execute contracts. Executive Director?
Good evening. I just want to be real clear. This is not about stripping the ability for the 49ers as the management company to sign contracts for non-NFL events. This is about requiring board approval for non-NFL events for the appropriate use of public funds. This is about compliance, accountability, and transparency. This is an introduction of an ordinance that amends various sections of the code to modify the Stadium Authority Executive Director's authority to execute contracts. The Executive Director is the Chief Executive Officer of the Stadium Authority and is responsible to the board for the proper and efficient administration of all affairs. The Municipal Code, Section 17.30, entitled Stadium Authority Procurement Policy, outlines the procurement policies and procedures for the Stadium Authority. The code authorizes the executive director to take several actions for the purchase of professional, non-professional, and personal services that are required to operate the Stadium Authority by entering into contracts less than $250,000. For contracts over $250,000, the contracts must come to the board for approval. In addition to those requirements, the code also requires that persons are specially trained and experienced and competent to perform the special services required. The executive director's authority may be delegated to contractors with the Stadium Authority. In this case, the 49ers Stadium Management Company provides management services including overseeing the day-to-day operations and maintenance, as well as the marketing and booking of non-NFL events. The board delegated the executive director's procurement authority to the stadium manager. As part of that delegation, there was an attestation that they were an organization whose principals have substantial experience and expertise in the management and operations of public assembly facilities. Let's look at the stadium manager's procurement responsibilities. They are authorized to contract for up to $250,000, and thereafter they must obtain the board approval for contracts above that amount. The Stadium Authority shall comply with the requirements of Public Contract Code, and as it's delegated to the stadium manager, they must as well. They must submit to the Stadium Authority Board a report at the end of the Stadium Authority's fiscal year summarizing the total number of contracts let by the Stadium Authority or by the stadium manager on behalf of the Stadium Authority. There were pre-opening obligations as well that should have carried forward. 3 of which are establish charts of accounts and accounting policies, maintain effective internal accounting controls with respect to compliance and applicable laws, and minimize the risk of noncompliance and to provide for the detection of any noncompliance within a timely period. In addition, the stadium manager shall provide contracts entered into with contract amounts greater than $100,000 within 30 days of entering into such contracts. The stadium manager shall also maintain complete and accurate books and records relating to the operations of the stadium and its services provided hereunder. The stadium manager must also use reasonable efforts to maintain separate records for the tenant season as well as the Stadium Authority season. So let's look at the performance. Remember, the stadium managers claim to have had substantial experience and expertise when taking on these duties. The stadium manager has never provided a report at the end of the Stadium Authority's fiscal year summarizing the total number of contracts that they issued. They've already admitted that they issued at least one contract for over $250,000 where they completed the work, invoiced the Stadium Authority, and violated state laws. The stadium manager has not maintained complete and accurate books and records relating to the operations of the stadium, and they're now proposing to charge us in order to assemble those records. The stadium manager has not complied with the state prevailing wage laws, public contract code section, as well as procurement requirements. The stadium manager has not maintained internal controls and contracts pertaining to the stadium in a manner that minimizes risk and the detection of noncompliance. It is unknown whether the stadium manager has fully complied with the disclosure requirements to the Stadium Authority with respect to the $100,000 requirement because we do not have access to their operational documents. All documentation has not been provided to the Stadium Authority when requested or when made through public records requests. The Stadium Authority is unable to assess the extent of procurement violations based on the stadium manager's admission of noncompliance with state prevailing wage and public procurement laws because they refuse to produce the documents. The stadium manager has not provided, nor does it appear to have maintained, separate records. The stadium manager has received a number of notices of breaches of notice or default, and it has not cured them. Now, they did produce some documents early on when we were trying to get information about the state prevailing wage, and they provided 67 capital projects. The title of the documents were 2019-04-12 SCSA Production File, Clean and Wiped. The Stadium Authority retained a forensic auditor to review the documentation. And what we found is that the management company used a project order form in order to transact the public's work, which is not legally sufficient documentation to contract for work. These are internal tracking documents that they used. In your packet, in your post-agenda packet, you have some copies that I'll walk you through so that you understand the mismanagement of public records. Of the documents, this is what the auditor found. There were 19 projects where there were no invoices, 46 projects where there were no agreements, 24 projects where there were no bids, quotes, or estimates provided. On some of the project order forms, signatures and dates were missing. Vendor signatures were also not obtained. Documents signed after invoicing. For projects potentially greater than $250,000, there were 4 vendors where in 1 year the cost did exceed $250,000, which should have triggered both proper bidding as well as board approval. Several instances of agreements between the management company and the vendor being signed after the work had begun and creating contracts after the fact. In your packet, you have Project 205.3. This is with RMI Mechanical Contractors. The quote for work is dated December 13th, 2018. The project order form is dated the same. It's not signed by the stadium manager. And we're invoiced on December 19th with payment due on December 29th. We advised the stadium manager on May 22nd to stop creating documents to create the illusion of compliance. Here's the project order form that's dated December 13th. Here's the invoice that's dated December 19th with payment due on December 29th. This is invoiced already, meaning that the work had already been completed, and their contract is dated January 4th, 2019. Project 196.1, DLI Mechanical Piping Contractors. This was a verbal quote for public works, guided by state laws for public work contracts. The quote was issued on May 30th, 2018. The project order form was created on October 1st. It was not signed by stadium manager. We were invoiced on October 17th with payment due on November 16th, and the agreement 3 months later on February 21st. On May 22nd, we advised the stadium manager to stop creating documents to create the illusion of compliance. Here's the project order form. Here's the verbal quote for work, dated May 30th. Here's the invoice with due date November 16th, 2018. And here's the contract signature page, February 21st, 2019. Those are the quality of the records that the 49ers chose to share with us, and this is what we detected. We don't know what the remainder look like or if they exist. There was documentation that was not provided, projects and contracts that exceeded $250,000, which would have required board action, projects and contracts not related to capital expenditure fund. There's the whole other side of operations for day-to-day expenditures that also have agreements and contracts for which we've received nothing. We did receive one AP printout, but we're not getting the documents that we asked for. There's no purchase orders for any contracts. Bid, estimate, quotes for many of the projects have not been provided if they do exist. Agreements for many of the projects and invoices. The Stadium Authority has asked for all documentation that supports operations and shared expenses. The stadium manager has not produced these documents. So let's go through the actions of the Stadium Authority. Despite the stadium manager's claim to have substantial experience and expertise, they have violated the state prevailing wage laws. The stadium manager has admitted that they have violated the state prevailing wage laws since the day they began operating as the stadium manager. The stadium manager has made no effort to disclose corrective action plans for day-to-day operations and allow for us to understand the extent of those violations. After 6 months, only one contract proposed for corrective action. The Stadium Authority issued a notice of breach as well as a notice of default that has not gone cured. In your packet, you have, as another post-agenda materials, documents related to Next Systems. And I want to walk you through slowly, if you allow for me, just so that I can highlight some of the irregularities with respect to their maintenance of documents and how they've managed public funds. This is an October 30th memo from the stadium manager, and it says that they're preparing to initiate work for the flooring in the amount of $495,000. On December 3rd, just over a month later, they sent another memo saying that the amount of work is now $643,000 and that the work had already begun on August 6th. This is the documents that they submitted to us to bring for board approval. They did indeed start the work. They got quotes in August, on August 15th, August 24th, and they submitted one document on September 6th. And I'll call your attention to the bottom right corner where they articulate that the hourly wage for labor is $160 per hour, and on weekends it's $215. I didn't want to put the second page on there just for it's already a lengthy slideshow, but I want to go to the terms and conditions of this document. In the document that they submit to the Stadium Authority for us to advance this contract for $643,000, the terms and conditions are standard labor rates for Cement Masons International Policy Union. On March 12, 2019, the stadium manager confirms that this is a state prevailing wage agreement or contract in writing. What you have around this room is the 49ers documentation of all of their wage violations for every individual where they violated the state prevailing wage law on this contract. And I'll just give you an example of how to read this. This one individual is due $2,873.27. This is the 49ers work, not mine. This is the one contract that they have cured. You'll see as the top line item under prevailing wage column that the employee was due $60.96. The employee was paid $18. This is not a paperwork problem, as the 49ers have characterized this. This is a state law compliance problem where they have not paid workers under the Stadium Authority the proper wages. This is another example where this employee is due almost $18,000 of back pay because the 49ers, although they attested in email to me, as well as in their own quote documents that they were paying the state prevailing wage law, where they paid way less, in some cases a third of what they were due according to state law. Every one of these documents is an example of an individual who did not receive the pay that was due for them under the stadium manager's contract responsibilities. Despite the stadium manager claiming to have substantial experience, they have already violated public procurement law since it began managing the stadium. They've made no effort on public procurement to try to correct on day-to-day operations. They've admitted to their failures to comply with contract procurement obligations and comply with state law. And we have issued them a notice of breach and a notice of default in June and in August, for which they still have not cured. On annual reports to contracts, we noticed them in March 2009. We brought forward our information on the Stadium Authority staff side for the board to approve, and they have not yet produced any of those reports. And we also issued a notice of breach of management agreement on August 21st, 2019, and they still have not cured or made any efforts. Despite the stadium manager's claim to have substantial experience and expertise, they have now begun to inappropriately use the revolving loan fund, which you'll hear about as part of the financial statement. The Stadium Authority's actions have been about transparency, accountability, and compliance. The stadium manager was advised that invoices would be paid with the appropriate supporting documentation to release public funds. The stadium manager has instead elected to issue itself $4.4 million of loans from the revolving credit agreement instead of providing the Stadium Authority with the supporting documentation. We have requested the supporting documentation as well as what legitimate purposes they are using these funds for, and those have also gone unanswered. We have objected and reserved all of our rights with the management's company use of this revolving loan fund to trigger a loan on shared expenses. Again, the stadium manager claimed to have substantial experience and expertise. They have not produced the Stadium Authority's financial documents. They have not complied with the agreement terms. Their records do misrepresent and lack transparency. They've created records after the fact to create the illusion of procurement compliance. They have violated state laws, as evidenced today here regarding workers' wages. They have not cured notice of breaches or default, and they have now started taking out loans on behalf of the Stadium Authority to pay for the shared expenses instead of providing the supporting documentation. It is for those reasons that we are recommending that introduction of an ordinance to amend Chapter 1730 to require the board approval before execution by the stadium manager of any contracts for Stadium Authority non-NFL events.
Okay. Do you want, okay, we can have questions now on this before we move forward. Thank you very much for that very comprehensive report. Authority Member O'Neill, did you want to speak on this?
Yes. So thank you, Stadium Authority Executive Director and City Attorney, for all the information, and I do appreciate the diligence with which you're working to protect the interests of the residents of Santa Clara. So in regards to this issue about the procurement authority, I think late today, all the members of the council did receive a letter from Jonathan Bass, who's one of the attorneys outside counsel for the Stadco. And they raised some issues about, and perhaps maybe the city attorney can chime in on this, about whether we can, if we can revoke the, or change the authority by doing this an ordinance. They claim in the letter, I don't know if you had a chance to read it, it came in pretty late.
I did skim the letter, and let me just kind of explain what the ordinance does, and I think that might clarify things. All the stadium manager has is an agreement that they have the full authority of the executive director. You're not changing the contract between the stadium authority and the stadium manager. All you're doing is changing your relationship with the executive director. The executive director has laid out a case where she's telling you, I can't provide you or the public with any assurance that the authority that you delegated to me originally when the procurement policy was adopted, I can't provide any assurance to the board or to the voters that this authority to contract is being used in accordance with the law. And by making this request to reduce that authority to 0 prior to board approval, the executive director is saying, I want accountability and transparency to the public, and the only way I can do that is to require all contracts to come to the board before they can be executed by the stadium manager. So we're not affecting the contract at all. We're just simply providing transparency and accountability to the public.
Okay.
The board cannot, you know, the assumption of this letter seems to be that somehow you contracted away your legislative authority. There's all kinds of California law that say you cannot contract away your legislative authority.
Okay, so
you cannot bind a future legislative act of a future council to say, hey, we no longer want to delegate. The authority to contract is the board's, okay? So the board is simply saying, we no longer want anybody else other than us to have the authority to enter into contracts for the public's money. And that's all you're doing tonight, is saying, you're not saying you can't spend any money, you're just saying, show me the contracts first. Show me the procurement procedures that you went through. Ensure that the workers that are being paid under this contract are being paid the proper wages under state law. Ensure that there's no conflict of interest in how you procured this contract. That's all you're doing. You're not in any way depriving them of their right to continue to sign contracts. They simply have to get your approval ahead of time.
Okay, thank you. So, they also make the point in the letter about, the issue of, all the relatively low-cost items, the regular supplies and different things that maybe would have to be purchased, or just even like they alluded to when the Stadium Authority Board's on break and things like that. So, did perhaps to our council and to the executive director, did you think about or look at the idea of having some low-level threshold that they could, like for just ongoing supply? I mean, was there discussion with the staff about that?
I just want to make a point about that. Then there's all kinds of, very well understood for people who actually have experience, ways of procuring open purchase orders where you pre-bid the goods. Our own procurement department does that. So this is really a red herring, this thing about low purchases. There's ways of properly procuring that and bringing those types of purchase orders to the board for approval. They could easily do that ahead of time, and then they could just purchase off those purchase orders for those kinds of things. And at the same time, the purchasing policy still allows them to purchase from governmental entities. They could purchase through us. Let's say there's some service contract that we have procured that they need to piggyback onto. They have the right to just simply come to the city and say, hey, we need somebody to do some plumbing work out here that the city has procured, and the city can just say, oh, just piggyback off of the contract that we did.
Or maybe, or even like I know the state has like general services types contracts.
Sure. Yeah, this is purely a red herring. Yeah. But the small dollar purchases is purely a red herring. The emergency purchases are purely a red herring.
What it does is it reveals their lack of experience and expertise in procurement. Anyone who is experienced and has expertise, they need a procurement strategy, and there's plenty of ways to facilitate and streamline legal procurements for small dollar amounts. There's purchase orders and other things of that sort. And so when I read that part of the letter, it actually revealed the lack of experience and expertise in public procurement that they claim to have.
Okay, thank you for the clarification.
Thank you. Authority Member Davis?
Thank you, Mayor. Executive Director Santana, this was very eye-opening, but one question, did all those bodies get paid their money? Is that still out there? Have they been paid?
We don't know. This is one contract. Keep in mind, this is the capital project that surfaced earlier this year. Multiply this by 5 years for operations and capital projects. The violations are significant.
So you're telling me that this is just one of 5 years worth of contracts, and we don't know about how many more there are? Wow. Okay.
That's correct.
That's right. Mayor, I would like to make. You wanted to just take A, B, and C together?
Done C yet.
So we're not going to. I would love to approve this ordinance and take the authority back to us, because basically what you're doing, and Councilmember O'Neill, thank you for. I'm sorry, Stadium Authority O'Neill, thank you for the clarification, because it just takes them to come here, because they're not here again, them to come here to make sure that everything is in its proper management process. So by taking that authority away from you, it gives it back to us to make sure that going forward, we have a better process. Am I correct?
You are correct, and you reference these documents in your post-agenda material. You actually have them printed out individual by individual. It matters. These are people who did not get their fair wages from the 49ers, and it is significant in terms of the amount of contracts and operational state prevailing wage violations. I want to say that because they will reflect that this is the executive director micromanaging, or they will reflect that we are being obstinate or too demanding. These are real people's lives who have been denied fair wages according to state law. And so if that's the case, we expect them to fully attack us on this matter, but these documents don't lie. These are their documents that substantiate just one contract where they did not pay $85,000 due to employees.
And I just have to emphasize as well, we still don't have itemized invoices of the work that was done for this contract.
For this contract, because...
Right, so they're showing us what these are their purported certified payrolls, deleting the personal names of the people. What we don't have is, remember they were presenting a contract to you for over $600,000.
Right.
We don't have anything anywhere near invoices saying, okay, this from the contractor to them saying this much work was done, here's this amount of money. Nothing coming close to $600,000. So they were asking you to approve a contract for the expenditure of over $600,000 to this company, Next Systems, and we still don't know what all the rest of that money was for.
Is that why they're doing the drawdown?
I don't know what they're doing.
Okay.
We don't know what they're doing.
Okay.
And they refuse to tell us.
Okay. Thank you, Mayor.
Thank you. Authority Member Hardy, and then Watanabe after that.
Thank you. That answers some of my questions over this is only one contract, $84,000. This was just for some painting on the floors on the main concourse. On a scale of how many things have been done or needed to be done at the stadium, if this is $85,000 that hasn't been paid, do we have any idea of what scale of items may not have been, contracts that were not done correctly? Do we have any idea?
We don't. That's the work that we've been trying to acquire since this first violation was identified, about 6 or 7 months now.
I think based upon what we know now, if they did anything correctly, it was probably by accident.
Authority Member Watanabe.
Thank you. I have just a couple of questions and a statement. Regarding the preliminary findings procurement review, and you mentioned in your report the documents provided that of the 19 projects where there were no invoices were provided, 46 projects where no agreements were provided. Did this come out as a result of an audit, or how did we find this information out?
When we discovered the violation of state prevailing wage, we asked them for all of their documents, and this was a board action, supported by the board action, and they provided 67 capital projects. Whether that's the universe, the full universe, or just select, I don't know. And we did is we hired a forensic auditor to go through the documents and provide a summary of what they found. And we have shared these results with the management company.
Okay, great. And then when looking at Next Systems, the invoice that was presented dated September 6, where it states that the workday rate, labor rate was $160 per hour, but they, in all actuality, they were only paid, what, $60 an hour? Is that the rate?
They were paid, the one example was an individual was paid $18 an hour, but should have received $60.96.
And so so we were billed for that entire amount, were we not? And then, but they only paid a fraction, basically, of what they should have been paid.
The documentation that they gave us that identifies the work is their rate is $160 per hour for the weekdays, and for weekends it's $215. They pay their employees $18 in some cases and $34 when they were due $73 an hour. And the invoices don't have any detail. So I can't fully answer your question.
Okay. Thank you. I think those are all the questions I have, but just in general, just to make a statement, this whole scenario reminds me of a similar situation that we were involved with in the city not too long ago regarding the chamber. I mean, it's like all of the nuances and the actions that we had to take as a result. So by taking this action, you know, as a council, I feel like we're curing the issues that they are not being accountable for, and we're also protecting our asset, which is, I mean, what, you know, we need to do as a council, you know, on behalf of the city. So basically, if I were in Stadco's and Manco's shoes, I would be really embarrassed right now, because after professing to be something that they obviously aren't, it really speaks volumes, and I really hope that, you know, we can move forward and correct what needs to be corrected. Thank you.
Thank you. Authority Member Chahal, and then O'Neill.
Thank you. Thank you, Mayor. Thank you, Chair. I had a couple of the same question which Board Member O'Neill had, like from that letter, from legality point of view. I think you answered that question. And I do recognize the violations, which are pretty grave and egregious. And my only suggestion over here is we are trying to take back blanket authority we gave to the executive director. And my suggestion would be, because any organization or a business or a public body has to run a day-to-day affairs and smooth running of that. And this is our $1 billion asset. So I would suggest that and going before that, we already saw how many lawsuits are pending between 49ers have come up with city. I would suggest that not to take the blanket authority from the executive director, but reduce it to a level where at least the day-to-day operations of the stadium are not impacted. They should not have an excuse that because of this authority being withdrawn from the executive director, we have to wait for 1 month to go to the stadium authority meeting, and we could not do any small safety-related issue or any small operation they were to do for something. So I would suggest that we can reduce the executive director's authority from 250,000 to say 50,000, at least, so that we can take care of day-to-day affairs of that.
Let me just give you the disadvantage of doing something like that, is that with a company that's already shown a penchant for bid splitting, then that's exactly what you would get. You would get bid splitting. In other words, they'd do incremental contracts under 50, so they wouldn't have to show their work to the board. And there's really no reason, with proper planning, there's no reason that they couldn't maintain operations. And those are our operations. We're not talking about their operations for their football season. We're talking about our operations. And there's absolutely no reason why they couldn't maintain operations. As I've said, they could come to the city and piggyback off their duly procured contracts. They could, if it was truly an emergency, they could request an emergency meeting of the board. There's all kinds of things they could do that would not interrupt their operations. And, you know, I certainly would not feel comfortable recommending allowing them any authority until they've shown a track record of showing that they can procure contract correctly. And and I don't think they have any real track record of saying that they couldn't operate this way. They can always say, hey, we don't want this authority. You, the stadium authority, do the procurement for us. They could say they could request that we remove their obligation to do that. And so, you know, I just don't see this as a problem, to be honest with you.
So my point is, we have full faith in the operations of our executive director. And you went to, when you say bid splitting, we had a 250K authority, which I know there were blatant issues and we are not going there. We already know that there were some big issues why we are discussing this topic. So from that point of view, they have to split that contract into 10 times. But I'm just trying to be, trying to manage it to an extent that this does not become a hindrance, another hindrance in the point of view, they pick up another thing about the stadium authority. Hey, now you cannot even do $500 job without going to a stadium authority meeting. That's my point. Like, we should not give them a chance to say that. And I'm not asking for and I'm saying the executive director should not even authorize any purchase or any contract if she is not satisfied to the best of her ability.
I think it gets back to what I said earlier, in that they claim to have hired now, 5 years later, procurement specialists and experts. And it really gets down to a procurement strategy. The adoption of an ordinance and a second reading, and then it going into effect 30 days, gives them well notice. We've already advised them 2 weeks ago, I believe, or a week ago, that this action was coming. They have the experts now on board. They just need a procurement strategy.
Oh, I agree with that.
Yeah.
I'm not even denying that. But what I'm trying to say is, I'm only talking about a very smaller amount so that nobody has an excuse. Because if there is safety-related issue and they say, oh, we proposed this thing and it took a month and something happens, it's an issue with the state. We are part and parcel. At the end of the day, we are stadium authority.
As the executive director, I would not recommend that. We already know that this is about transparency, accountability, and compliance. We already know that they have created documents to create the illusion of compliance. We already know that they have misrepresented that they complied with state law when they haven't. And I just think that the examples are serious in nature enough that to give them a $50,000 level, there will be an amount that we still will not know what they are doing with the public's funds.
So basically, you as executive director doesn't feel confident of even handling up to 25K or
I think
50K.
with the representation by use of their own documents that they submitted to us, it really illustrates how they have managed the delegated procurement authority. And I think it would be a very serious decision to allow, and significant decision to allow for them to maintain a level of procurement authority that...
So let me come to, I'm not asking, give them the authority. They will have to come to you to get that up to that amount.
And that was my point when I first answered your question. You already seen the documents that they gave to me, and you see how they have claimed to represent that they have complied when they did not. And so there's nothing to say that that would not change.
Okay.
Or that would change.
Okay, thank you.
Thank you. Authority Member O'Neill.
Yes, I wanted to kind of return to the point that Authority Member Watanabe touched on, and that's where if you look at, you know, in some of these examples that we are given for this one contract, where what the prevailing wage was supposed to be and the rate hour that was paid, have we been able to analyze the invoices enough to determine was the stadium authority thus like kind of billed at the prevailing wage rate? And, you know, I just don't want to make sure, you know, I don't know if there was a discrepancy, or if we have enough data to know.
The invoices don't have any details. What the invoices show is Terrazzo, $200,000. There's no detail in terms of anchoring back to the level of work, where the work was completed in the stadium, as well as the employees that were paid.
Okay, thank you.
And just for the record, they did reimburse the stadium authority back for this contract.
Thank you. I just had a couple of comments because this is the contract that came up when They came for approval after the fact when it was discovered that the contract was over $250,000 and they needed stadium authority approval. So they came months later to get our approval. And, well, first of all, let me ask, is there any representatives? Is Jim Mercurio here, our stadium manager, or any representatives from Manco or Stadco? Just wanted to check. When the representative came up and said they had 3 bids with 3 qualified bidders, and we asked them to provide the proof that we wanted to see the bids to make sure the bid was the lowest bid, because it seemed like a lot of money to paint concrete. So we were questioning it was in the $600,000 range, and they said, oh, no, we'll give you those bids next week. Well, certainly they never came, and then I think the fact that you've now discovered all this just on one contract. But what I find interesting is on the email from Jim Mercurio, he says, further, we can confirm that this project was a prevailing wage project. So that shows that when we discovered that they were not following state law and paying prevailing wage, or we thought, we're asking them about paying prevailing wage for 5 years on the management of the stadium, they actually knew what prevailing wage meant. Which is disturbing because when you look at all these individuals who were denied the prevailing wage for this project, I think they call this wage theft. I think that's the term that they use. But for the money that wasn't paid, where did it go? Because I think that's what these authority members are asking, if the stadium authority paid based on prevailing wage, but the workers weren't paid the prevailing wage. And this is just one contract that they actually provided to us. So when Authority Member Chahal talks about giving them authority for $50,000 at each event, I would never do that, knowing that they have already violated so many things, including the law, the state law. Why in the world would we give them additional public money to continue to do that when we have not been assured that they are complying with state law among all the other things in the contract? I can't in good faith continue to pay them 50,000 over 50,000 when they don't provide us any information. The Stadium Authority Board and the City Council, we meet a couple times a month. Sometimes it seems like every week we meet. We can call a meeting at any time, especially if it's for the benefit of the public and the non-NFL events. We want this to be successful. So we will make sure as soon as we're assured that they are, at the minimum following state law and doing what they're supposed to be doing as managers of a public facility and public funds, then we will do that. But until that happens, we can't in good faith continue to give them money with no accountability, transparency, or compliance with our management agreement. We can't, as representatives of the public and protecting the public funds on this public facility, we can't give them, I'm sorry, with all due deference to you, Authority Member Chahal, I cannot let them continue to take $50,000 shots of public money. So I'm in favor of this until they can prove that they are actually following state law. But after all of these items that you have pointed out, Authority Director, it's overwhelming. It's overwhelming. If any of us had any personal property that we were managing and our manager did this to our own, I mean, they would have been fired immediately. So I think that, we've done everything that we can, and until we can prove that the public money is being spent wisely, we have to be able to have a say in what contracts are approved, because that's the only way we're going to see contracts. Up until now, we haven't seen anything except this one contract, and look what it resulted in around the room here. Not paying prevailing wage to these workers that are working really hard over there, and they're not getting paid what they should be paid. Okay, Council Authority Member Chahal.
Chair Gilmore, I just want to clarify, I'm not giving them any authority. I was of the point that authority to executive director to do that. I just want to clarify that everything still comes to the executive director, and she is the final authority even to pass any amount we finalize. So I just want to clarify, no authority to them, just to our executive director. Thank you.
I hear what you said, but apparently you weren't looking at the PowerPoint because she has not been able to get any documents whatsoever. So I just don't want to continue the practice of them spending public money and not providing the documents to the executive director. She clearly stated that she has not been able to get the backup documentation, so I just don't want that cycle to continue with public money. Thank you. Anyone else on the council? Yes, Authority Member Davis.
Sorry, Brian, under the DLI mechanical piping contract, stadium executive director, it says, we have based our proposal on a verbal instructions of Mr. Damian Andrews and the site visit. Is that, do we have to have, is there anything in the contract? Can you clarify that? Is that a verbal contract is as legal as a written contract? So that's...
As far as I can tell, nothing they've done is correct in terms of how you would do it. So there's no such thing as a verbal contract with a public entity. I mean, you have to have a written contract.
Okay, because I'm trying to understand, it said, and site
It sounds
visit.
like, it does sound like the work was a public work, which meant that you wouldn't do verbal bids, you'd do a public bid opening, sealed bids, and take the low bid. So I don't, there's no specs, there's no nothing. I don't know what this is that they submitted. I mean, it's just, I don't know. I hesitate to characterize the piece of paper as anything other than an attempt to get public money to pay a third party.
Okay, because underneath it has scope of services, exclusions, conditions. So how did this happen? How did a verbal, I mean, did this guy just make numbers up in his head? I mean, I'm just
we
kind of
don't
curious
know.
as to how we even get this stuff.
No, I mean, it's very, in a real public works contract, you'd never let the bidder create their own terms and conditions. You
But that's what this says.
I know. That's why
Okay,
it does
all
not
right.
appear to be a correct
Okay,
contract.
I just want to thank you. I just want a clarification on that one.
All right.
Okay, I don't see any other questions from the Authority Board. Why don't we go on to the next item, and then we'll also go to the public. Welcome.
Good evening, Honorable Chair, Stadium Authority Board members, Ken Lee, Stadium Authority Treasurer. I have a short presentation for you. The item before you is recommended a note and file of the Santa Clara Stadium Authority fiscal year 2018-19 annual financial statements. And I have several slides that go through the financial statements, and then I'm going to turn it over to the General Counsel to talk about performance rent and implications related to Measure J. First off, from audit limitations and methodology, this was an audit of the Stadium Authority's financial statements and internal controls based on information provided by the Stadium Authority and Stadium Management Company. The audit opinion is not for any other city entity, nor any 49ers entity. This audit was not a compliance audit. Specifically, it's a financial statement audit. This financial audit is an independent evaluation of the Stadium Authority's financial statements and reporting processes to provide reasonable assurance that the financial statements are free from material misstatement. Through various audit processes and procedures, auditors determine if relevant controls and processes are in place for the fair presentation of the financial statements in accordance with GAAP. Just as an overview, this slide summarizes KPMG was selected to perform the annual audit of the financial statements as required by Section 5.1A of the credit agreement. The financial statements cover the 18-19 fiscal year, which is April 1st, 2018 through March 31st, 2019. They provided an unmodified or clean opinion expressed by the auditors. It was presented to the audit committee last week on September 10th, and the reports are available on the Stadium Authority website. Taking a look at some of the numbers, this slide shows the assets and liabilities and summarizes the Stadium Authority's net position that increased by $17.3 million compared to the prior year. Total assets were a little over $800 million, with the largest being the stadium itself, carrying a value of $749 million net of depreciation. Liabilities totaled $768 million, made up mostly of outstanding debt, totaling $340 million, and unearned revenues related to the SBLs and the naming rights. Overall debt payments during the year totaled $61 million, with a reduction in principal of $42 million. From an operating revenue perspective, during the year there were 10 NFL games, 12 ticketed non-NFL events, 100 smaller events held at the stadium, recognizing $107 million in operating revenue. The largest of which are two categories listed here: charges for services, which includes non-NFL event ticket revenue, NFL ticket surcharge, which is 10% applied to NFL tickets, non-NFL ticket surcharge of $1.6 million. This is $4 a ticket applied to non-NFL events, and then senior and youth fees, which is 35 cents per ticket. The second category, rents and licensing revenues, totaled $45.3 million, primarily from stadium lease rent and SBL revenue recognition. From an operating expenditure perspective, the Stadium Authority recognized $85 million in operating expenses, the largest of which is material, services, and supplies, totaling $66.5 million, $51 million related to non-NFL events. Selling, general, and administrative expenses, which includes our Stadium Authority staffing, salaries, and benefits, totaled $668,000, and depreciation of $16.7 million. So I've summarized the operating revenue and operating expenses for non-NFL events, and bottom line total for net non-NFL event revenue totaled about $19,000. This next slide dives into the details of the non-NFL events by ticketed category and non-ticketed events since the inception. So since 2014-15, the bottom line there, the general fund, which receives half of that net NFL, non-NFL revenue, was totaled approximately $2.5 million a year, and for 18-19, as Brian mentioned earlier, we received $0. I would like to mention that the budget continues to assume about $2.7 million in non-NFL performance rent to the general fund. We will be coming forward in October and November of this year to rebalance that both on the general fund side and on the Stadium Authority side. And with that, I wanted to turn it over to General Counsel Brian Doyle.
Thank you. I'm going to continue this, and then we'll have questions. What I really want to do is, as a city attorney who happens to be a resident of Santa Clara and who lived through the entire Measure J campaign, I just want to go back and remind everybody that in Measure J, they said over and over again what the economic benefits to Santa Clara would be. And one of the most important aspects of this were the benefits of having the non-NFL events in terms of providing the ground rent at the fair market value and the performance rent. And they came up with figures as high as $155 million over the life of the management agreement. And you saw on the last slide that last year they charged us $7.5 million in management company services to produce projected revenue of $0. They represented and got a management agreement, a no bid, members of the press, no bid contract for management of the stadium for 40 years. There was never any competition. The only representations that were made to get this agreement were the ones they made to the voters, promising them as much as $155 million. Again, they referred to in their ballot materials of this revenue as guaranteed net revenue to the city. And again, the figure of $155 million. And there you have again the figure of $155 million in additional rent produced by the non-NFL activities at the stadium, for which they supposedly had expertise in running. This is a table from the Kaiser Marson report in 2012, again referring to what was projected as the net performance rent over the life of the lease. they were telling us in this report, they were telling us you needed to have a certain amount of that net performance rent in order to make fair market value for the ground lease of the rent, the rent for the ground lease. And the fixed rent for the ground lease was only a part of that fair market value, that you needed to have some performance rent to make the fair market value rent for the ground. This is to prevent the gift of public funds. This was to prevent a subsidy by the taxpayers of their ground rent. Again, the performance rent was projected to be, in this last budget, $2,697,000, and it ended up being nothing. We are now out, and we expect for next year, because there will be no net revenue. They already told us there will be no net revenue for the current year that we're in. We will have 2 years in a row of no net revenue or minimum net revenue producing no performance rent. This means for 2 years in a row, we will not receive the fair market value of the land that we are allowing the stadium to sit and for them to play their football games in. We also are missing that amount of money in our general fund, which we were counting on to provide services to our citizens. What happened to that money? Let's look. These are the events that they booked, that they supposedly are experts in booking for non-NFL events. Please notice all of the money-losing events. So essentially what happened is you have the 3 non-NFL football games totaling approximately $4 million that will produce in negative revenue. This means that the Stadium Authority is basically paying these entities to have their events at Levi's Stadium. This is the reason that we're going to have no net revenue this year. Gee, I wonder what happened to our performance rent. They paid it to the Pac-12. They paid it to the Red Box Bowl. Guess who owns the Red Box Bowl? The 49ers. They paid themselves our performance rent. Voters, does that sound like the $155 million that they promised you in 2010 when you voted for Measure J? I don't think so.
Okay. Does anyone have questions? Authority Member Davis and then Watanabe after that.
Thank you. Board Director, Ken. You're the man of the hour. If we're negative on this and we're not getting this performance rent, how are we paying the debt? Where is the money coming from? Our general fund? Where is it coming from?
So the performance rent, based on the agreement, half of that minus the ground rent comes to the general fund. So without that revenue in the Stadium Authority financials, other activities would have to pay for the debt. SBL revenue would have to pay for the debt. So there are other revenue streams specific to the Stadium Authority that would have to cover the debt payments. Now, from a general fund perspective, we'll have to find a way to balance out that $2.7 million that the general fund's not receiving. And so we'll have to bring that back to the council.
Just want to add
Without
SBL
violating
revenue.
Measure J. That was the big thing. So how are we doing this?
I just wanted to add SBL revenue as well is a source of revenue to pay down the debt.
But that
And
expires in 10 years, am I correct?
Let me just remind the council that we won the rent arbitration, so we do get $24.5 million in facility rent from the football operations. And a lot of that money goes towards repayment of the debt, as well as the SBL revenue.
So we can use that money then?
Oh yeah, I think we're okay in
okay.
terms of paying the debt. It's the issue.
Not general fund,
The issue is
okay.
not repaying the debt.
Thanks, Ken.
No problem.
Authority Member Watanabe.
Thank you. I just want to say one thing, the expression that a lot of people know, fool me once, shame on you, fool me twice, shame on me. This is why we've got to take the actions that we're taking tonight. Thank you.
Thank you. Authority Member Chahal and then O'Neill.
have a basic question and comments on this one. Like, we have a report from KPMG, and internally we are saying that we do not get the financial data from management for the stadium authority. So are we agreeing to what data we have on KPMG report, that this is a fair and good data? A clean data, we can believe the figures?
So KPMG has access to the documents and financial data that's provided by Manco and provided by the Stadium Authority. And so what they do is they take a random sampling of some of that data, and based on their methods and expertise in that field, they come up with an opinion based on how we've booked and represented the financial statement. So I do want to make sure that the audit that you're looking at before you is strictly from an financial statement perspective for the Stadium Authority itself.
I want to add that I asked that question of the auditors at the audit committee meeting, and the documents that they review for purposes of completing the financial statements are summary documents that are created by the 49ers.
So my question is going even further, like, when they come up with these, when they validate these figures, we as a stadium authority has every right to ask our auditors, hey, how did you come to these figures? And we have every right as a stadium, because we own the stadium, we own this agency as such. So we have every right to go to them, how did you come to this figure? Did they ever consult our staff that these are the numbers, these are good numbers? And how can we take this for granted when we say we do not have access to the financial data of the Manco, which is providing all this data? So I'm a little bit concerned about it, that as a fiduciary authority, as a board member, if we stamp this thing, we are not doing justice to our residents and ourselves even, that we are stamping out something which we are not sure whether these numbers are right or wrong. That's my biggest concern. Like, how can we agree to this thing, just file it up and we say, okay, this was good, no problem. But
You raise an excellent question, one that we have posed to the management company, in that in their refusal to provide us with documentation, or in their suggestion that we pay for them to assemble the documentation, we have asked that same question. How are you determining your shared expenses? How are you building budgets? How are we doing financial statements if you're telling us that you have to charge us to assemble the documents? We've asked that same question. We have no answer.
so my question is, they are not cooperating, but we are hiring KPMG to do this audit. We should write to KPMG, hey, this is what we need from this audit. We should be going into deep dive into it. This is what we need, where these figures are coming from. We should use our authority to deep dive into it. If they're not providing, we have a way of getting that data from them.
We had the discussion at the audit committee, and for purposes of the financial statements, they felt that their work was complete. They represented that it was complete, and the information before you. They did state that the conversation that we were having at the committee level really was the subject of a compliance audit, and that was not the nature of this audit.
Yeah, but within the compliance audit also, the financial figures have to be supported by some documents.
Happy to work on that
Yeah,
with you.
I would
happy
suggest,
to work on a financial compliance audit with you. I think there's a lot of justification for one.
I would suggest we should write a detailed letter to them, what they should have done, and what the intent of the audit should be, and what numbers we need and how they should.
If that's the pleasure of the board.
I would suggest that.
Can I ask something, because this kind of goes to what happened, and every year I sit down on the audit committee and we look at this. Some years the audit didn't even come to us. We had a previous city manager that said we didn't even need to approve it, and he just sent it on because it was for the lenders. But here's an example, Authority Member Chahal. At our audit committee meeting, they had numbers, KPMG had numbers down for number of tickets sold for non-NFL events. So I asked them, where did you get those numbers? And they said, Manco. You know, the 49ers gave us those numbers. And we asked, did you see any backup documentation for those numbers, such as, StubHub or something to back that up, and they said no, they were provided with the numbers, and that was their job. So I ask every year, are we actually approving and saying these numbers are, they're just numbers that they're given. We hired Harvey Rose to do the audit, and which was a performance audit. Harvey Rose went to Manco and Stadco, and they refused to give them any documentation. But the auditors at our audit committee meeting said, if we want that, we need to hire them or someone else for a compliance audit. But I feel like we'll still come up with the same situation when the Harvey Rose folks asked for information for our own audit that we paid for, they wouldn't cooperate. So I hear what you're saying. It comes up every year. What is the action tonight, to just note and file? I mean, the audit, it's just a note and file. We're not saying that this is, maybe we can make our statements that these numbers are the numbers that the 49ers gave them, and we can't verify because there's no backup documentation.
And
so,
we too have asked for, we have asked several times for the actual reports from the ticket selling agency, not the summary reports that the management company provides. We've been denied that information.
So I would suggest we will note and file, but we should note and file with all these comments and a letter, strong
agreed,
letter
we
to
can make
KPMG,
statements. Yeah.
KPMG, so that when they come next year, at least they know, okay, this is what was demanded by the stadium authority last year, and they should do that.
Well, we'll have to change the scope of the audit then. Because this is an audit, isn't it, finance director, for the lender?
Compliance.
Don't we would
That's
have to
correct.
change the scope
We'll
of the
have to
audit?
do a separate standalone stadium authority audit.
Right.
And from that perspective, I would be going forward, we have an internal auditor. I should think we should use internal auditor services to deep dive into that.
Again, Authority Member Chahal, I just want to, refer you to our PowerPoint where we can have our internal auditor that we've tried to get information and there's no cooperation. So good ideas, we just need cooperation. Authority Member O'Neill and then Hardy.
Thank you very much. And sort of following on that, the Stadium Authority Chair mentioned about the Harvey Rose audit, which some of us took a lot of beating for that. But because I think some of us were concerned from the very first time that we got financial reports. Some of you will remember my favorite $5 million number that kept popping up all over the place, like, where's Waldo or something? Oh, there's the $5 million number again. And I thought, speaking about, as we found out some very good information, we found out some of our own internal weaknesses, and we've made some corrections. And we did hit some walls, and actually I found it telling because we talked about going into a second phase of that audit, and I thought it was very interesting that Harvey Rose told us that, we're going to be busy, so don't bother asking us to come back. So I thought, oh, this is great. They don't even want to take it on. One of the things I thought was kind of interesting is usually when we have these audits, we've already had the quarterly or year-end financial reports from your department, your predecessor, Angie, and now you as the Stadium Authority Financial Director. So is it a little unusual that and I know we've mentioned about the requirements with the audit, with our lenders, which we are due to the the stadium rent and the SBLs, we are still making good progress on, I want to assure our residents we're making good progress on paying down that outstanding debt, and that's what this really is intended. But wouldn't we usually have our own financial reporting done for the year end before we would be looking at an audit?
So for the fourth quarter report, so both last year and this year, what we've done is we've wanted to have the audited financial statements come first so that when we present the data in the fourth quarter report, those are audited numbers for you. We've also had some transition as far as staffing in the finance department. So our plan is to bring forward the fourth quarter report to you as part of the October 29th Stadium Authority Board meeting.
I just want to add that also the fiscal year ended at the end of March. We didn't get fourth quarter documents until the late July, August timeframe, I believe. And so we will be coming forward in November.
Okay, all right, thank you. So one of the things too that I did notice, and, and I appreciate that I understand completely the frustrations of a fellow board member, Shahal, on this, but, it's like looking at what are all the, these types of audits and what is the information we glean from them, and looking about whether we need to do a compliance audit or try to do another performance audit or whatever term we want to use. And I know that the city's tried to do forensic accounting and all of that. So, we've got that. But I did find interesting, though, that the KPMG did include that comment at the end. I mean, it was considered a clean audit. And this was one of the things that was kind of referred to in one of the earlier presentations, that note number 8, the subsequent events. What was your take on that? So the note 8 was speaking about the July 3rd issuance of a certificate of loan to the stadium authority by the management company, just for the members of the audience who maybe aren't looking at the documents. So that they had the ability, so when we had this dispute about where we weren't paying them because they hadn't provided all this documentation that we've been talking about, was, in your experience and with working with KPMG, was it unusual to have that kind of comment or crop up on this kind of audit?
So just for some context, what auditors do when they look at the financial statements and related to the notes and subsequent events, any kind of substantial event that from an audit perspective an audit firm feels that would be necessary to disclose, we talk through that with the audit firm, and they discuss it internally. And from a perspective of the revolving loans that you mentioned in note number 8, they did feel that that was warranted in the documentation, and so that's included in the financial statements before you.
So, but like for many of us, I know for myself, when I looked at the audit committee agenda and read the report, that was the first time that I knew that had happened when I saw that. So thank you for KPMG, because it was the first time I knew that had happened. Okay, all right, thank you.
Thank you. Authority Member Hardy.
Thank you. Just really quick. So to piggyback on this idea of a clean audit, so that's saying that the stadium authority is doing their part. We have our correct records. We've done everything possible. Is that what we understand by this unmodified clean report for the stadium authority?
Yes, that's correct, based on KPMG's review of the stadium authority financials using the methodologies that they look into audits. That's correct.
That we're doing our part.
Correct.
Thank you.
Thank you. Thank you very much, our Stadium Authority Finance Director. Is there any other council authority member questions for staff? This was our last item, right? So before we take any action, I'm going to ask if there is any member of the public that would like to speak. Assistant City Clerk, do we have any cards? Okay, on any of those 3 items, please feel free to come forward. Good evening.
Good evening. My name is Mary Grizzle. I am appalled at what I'm listening to and what's going on here. I wrote a speech and I was prepared to read it, but I would like to say that in lieu of everything else that's come up, I'm going to try to finish the speech after I say what I'm about to say. The ass whooping that this city council gave the 49ers a few months back is going to be very, very minor to the ass whooping that this city citizens group will give to the 49ers if this continues. I'm very upset about all this. And I will try to finish this speech as quickly as I can. First of all, I would like to commend the city council for making transparency in our government a priority. I would also like to say I am very proud, Santa Claran, to have a class act such as the 49ers playing in my backyard. After all, we are only one of 32 cities across the USA to have this luxury. I try very hard these days not to be political, but sometimes it is very difficult when you have been taught all your life that you have to stand up for what you believe to be true. Now everyone knows that the relationship between the 49ers and the city council are at odds. You see, I have let this ride for as long as I can without any comments pro or con. You see, I am working very hard to make Santa Clara a pearl of California. This year, I am one of a few women who are bringing back a huge event, the Parade of Champions. And in 2 years, I want shovels in the ground for reclaiming our downtown. I'm also involved heavily in that. It is because of the downtown project that I find myself at odds with this feud between the 49ers and the city council. The council already knows how important the downtown project is to me. The 49ers do not. For now, let me just say I will not stand for any one person or group to spoil my chances of making a downtown a reality. 49ers are interfering with that. Having said that, I recently learned of some disturbing shenanigans going on behind the scenes, and this is minor compared to what I've heard today, that is costing the city a huge amount of money and probably the reason they were recently investigated by the grand jury. This is a form of harassment that could cause delays in my dream of having a downtown soon. The grand jury made one mistake in coming to their conclusions that the city wasn't responding quickly enough to document requests and the like. They failed to compare stats from surrounding cities. 2 cities came in above 100 requests per year, and 3 others below 100. The city of Santa Clara weighed in at over 1,200 requests. Some of the requests, and I saw the paperwork, stood that tall. That's about 2 feet of paperwork for one request. And guess what? It doesn't take a genius to know that there's something really, really wrong with this picture. Lo and behold, I found out that over 70% of the total requests came from the 49ers camp and our companies doing business with them, such as their attorneys and accountants. In conclusion, I am asking the 49ers to come to the negotiation table in earnest, just as it was done many years ago. Back in the day, negotiations was a term for discussing contentious matters in a give and take situation. However, if this doesn't happen, no amount of training in your camps will prepare you for the wrath of the citizens of Santa Clara if they feel like they are being cheated. Thank you.
Thank you, Ms. Grizzle. Would anyone else like to speak? It's a hard act to follow, but would anyone else like to speak? Okay, seeing none. Authority Member Davis.
I'd like to make the motion. So for clarification, do you want A, B, and C separated, or?
I think the ordinance should be an approval.
Okay,
So why don't we do that one separately, and then the other
Okay.
2 can be a note and file.
we'll start with A.
No, A is a note and file, right?
Yes,
So is there a motion to note and file A?
yes.
Second.
Motion second to note and file A. Let's do them one at a time
Okay.
because they're all different actions. Okay, there's motion second. Any discussion on A? Please register your vote. That's approved unanimously of those present. So
Okay,
then B on the ordinance.
Okay, so the motion would be to introduce an ordinance to amend Development Code Chapter 17.30, Stadium Authority Procurement Policy to remove the Executive Director's delegated procurement authority.
Is that the correct motions?
Yes.
Stadium Authority and Attorney?
That's what it says on here.
Want to make sure.
That's the exact title of the ordinance at this point, but I think you can approve the ordinance. Why don't I pull up the ordinance and we'll
Now
read
let's look at it.
it. You can go to the other one first.
No, let's do this one first.
Was that? Yeah, that is the right title. Okay. It's the top one. Introduction of an ordinance. It's approval of the introduction of an ordinance to amend section 17.30.080, 17.3090, and 17.3120, modifying the Stadium Authority's executive director to execute contracts.
Was that your motion,
Yeah,
Authority Member
but
Davis?
on my recommendation, okay, yes.
Get that, Assistant City Clerk?
Thank you,
Motion and
Nora.
a second on that.
And I want to second it.
Any discussion from Authority Board? Please register your vote. And that passes unanimously of those present. And then
And on 2C, a motion
action
to
on the
note,
audited Santa Clara Stadium Authority fiscal year 2018-19 annual financial statement.
motion to note and file.
The motion to note and file. Did we want to make any comments with that?
Chair.
Anyone? Authority Member Chahal?
Yeah, so I would like to add the comments we did discuss that we need to send a letter to KPMG about getting all the data. And going forward, we need the Stadium Authority staff is to be actively involved in the audit process so that whatever documentation, financial documentation KPMG is looking at, the Stadium Authority can look at the same time.
Should we make that a separate action? I'm asking Authority, because what should we do with this? Because that was really long, so how should we
Yeah.
handle that? Our comments?
You should probably just note and file the audit. I think I just want to, just so you understand, council member, that KPMG is finished with this audit. I mean, are you saying that KPMG should do something different for this year? Or are you talking about next year?
I would, even for this audit, I would like to send comments from the Stadium Authority that the numbers or the figures what has been presented has not been verified by the Stadium Authority Board. And as such, we are not confident about these numbers. And going forward, we need to deep dive into it, and how these financial numbers are coming up, we need to have a process for that.
I think we can just simply forward them your comments in conjunction
Okay,
with the motion.
we can forward those comments with
That's
our
fine.
note and file.
Right.
So,
I don't think Nora can type that fast.
yeah.
No,
As
but
a separate
let's
letter,
forward
that's fine.
those comments with,
Perfect.
because I agree with those as well.
Perfect.
So there's a motion and a second to note and file with comments forwarded. Please register your vote. And that passes unanimously of those present. All right, thank you very much, staff, for this very, very comprehensive report and for providing us with all this information. We appreciate it. We're sorry it had to come to this. All right. Would the council authority like a 5-minute break? Okay, we're going to take a 5-minute break. Thank you.
We go into public presentation after that?
So our next item on the agenda is public presentations. Do we have any public presentations, Assistant City Clerk? Would any member of the public like to make a public presentation on anything that's not on the agenda? Please come forward. Okay, seeing none, consent items pulled for discussion. We don't have any. So the next item we have is the item number 3, which is direction to finalize terms for a residential recycling agreement with Recology and exclusive franchise agreement for collection and transportation of garbage, organics, and commercial recyclables with Mission Trail Waste Systems, and to enter into negotiation with Green Waste Recovery, Inc. for solid waste processing, transfer, transport, recycling, and disposal services. Welcome.
Good evening, Mayor and Council. Craig Mobeck, Director of Public Works. So I just wanted to give a brief overview of some of the key points of the discussion tonight and the items that we'll be presenting. Here is the overview, and I really wanted to focus on 3 main areas. As you mentioned, staff has spent a lot of time over the past 9 months approximately working with Recology and Mission Trail Waste on negotiations for future contracts. And so as we go through the items tonight, you'll see that we'll be requesting a few different things. So the first that I wanted to highlight is that we'll be requesting a direction from you to complete the negotiations with Recology. We'll be sharing the information with you and going over the estimated rates at this point, but we would like to move forward and complete that negotiation. So that is one action we'll be requesting of council. The second one has to deal with the Mission Trail Waste Systems Agreement. In the information, we'll be presenting 2 options in terms of the food scraps program. So the first option has to deal with the split cart that is currently being piloted. And then there's an option 2, which would deal with putting food scraps into the green container. And so what we will be asking council tonight is for direction on which one of those options to move forward with Mission Trail. So we'll be going through that detail, but we want to ultimately know if you'd prefer to go with option 1 or option 2. And then the third has to do with negotiations with Green Waste for potential mixed waste processing. And so we will go over some of the information with you in terms of that program, but ultimately we would want direction from you to be able to proceed to negotiate with Green Waste on mixed waste processing. So I am going to turn it over to Dave Staub, Deputy Director of Public Works, who along with Garth Schultz, who's a consultant from R3, who's helped us negotiate these contracts, and they will go through the further details of the presentation. Thank you.
All right, good evening. Just to start, to give you a little bit of regulatory background, Assembly Bill 1826 was signed into law in 2014. It requires commercial customers to divert organic materials from landfills. In 2016, Governor Brown signed Senate Bill 1383. This requires a 50% reduction of organic waste disposal by 2020 and 75% reduction by 2025 from the 2014 levels. And it mandates cities to implement organic waste diversion programs. So, yeah, the pie chart on the side shows, why it's an issue. Landfills make up 20% of the methane emissions in California. So in October 2017, we launched our pilot food scrap recycling program. About 4,800 residents were provided with a split cart container, one side for food scraps, the other side for garbage. The food scraps are taken to the Sustainable Alternative Feed Enterprises in Santa Clara to become an additive to animal feed. Advantages to that program is it's the lowest cost option. There's no additional containers needed for townhouse customers. In Santa Clara, we actually have a townhouse customer service where customers are not required to subscribe to a yard waste collection service, our Clean Green program. If they don't have front yards in their front yards, backyards, they've got HOAs that take care of their yard waste. And feeding animals is a better and higher use of food scraps than composting. Some of the disadvantages are loss of capacity in the garbage portion of the container, and we have experienced some issues with the durability of the containers. We did conduct two customer satisfaction surveys of the pilot food scrap recycling program. In our most recent survey, we received 1,254 responses, which is a 26% response rate. 57% reported that they were satisfied or somewhat satisfied with the program. 35% reported they were unsatisfied or somewhat dissatisfied, and 8% at the time were undecided. Just an overview of the current agreements that we have in place for solid waste collection, recycling, and disposal. With Recology, we have an agreement in place that we recently amended earlier this year for the residential recycling program. It expires December 31st, 2021. We have an agreement in place with Mission Trail Waste Systems that expires December 30th, 2021 for the collection of residential garbage and organics, as well as commercial garbage and recycling at all properties zoned for not zoned for industrial use. And then we have a landfill disposal agreement with Republic Services BFI, which is set to expire December 31st, 2024. And that's for landfill disposal and green waste composting services. We currently just have rates agreed to for composting our yard waste, but we have spoken with Republic BFI, and they have indicated that food scraps and food soil paper could be added to the green waste for composting at their facility for an additional cost. On November 13th, 2018, Council directed staff to enter into successor agreement negotiations with Recology and Mission Trail with the following main goals: increase landfill diversion to 75% or greater, comply with short-lived climate pollutant regulations and other state laws, minimize hauler profit, base future price escalations on documentable costs and industry best practices, and to develop a flexible revenue structure from recyclable materials. So with that, I'm going to turn it over to Gar Schultz from R3 Consulting, and he's going to go over the tentative agreement terms with Recology and Mission Trail.
Thank you. Welcome, Mr. Schultz.
Thank you, Honorable Mayor and Council members. Again, Garth Schultz with R3 Consulting. We're your consultant supporting city staff on these negotiations. I'll present first on the tentative points of agreement with Recology, which is relatively straightforward. And as listed here on the slide, these are the main highlights. First is that it's an approximate 15-year agreement going through June 30th, 2036 in order to align with the city's fiscal year rate setting adoption process. Typically, these have been 10-year type agreements. With a 15-year agreement, one of the things we've been able to achieve with Recology is a slower ramp up in a rate increase or a compensation increase to the company due to the ability to spread the amortization of new capital equipment needed for providing the recycling service over a longer period of time. That capital equipment would be new renewable diesel trucks with commensurate climate action and emissions benefits to compressed natural gas. And these are the type of fuel mixes that are currently in use by Recology, but they would be purchasing and using new trucks pursuant to a new agreement. One important benefit that's been secured for multifamily dwellings is the distribution and replenishment of recycling bags for use in unit. It would be both an educational piece and a resource for those living in multifamily dwellings that share recycling enclosures. They don't have their own recycling bin to set out on a weekly basis. They would use these bags in unit, bring their materials out to a centralized location, and then Recology would be providing those to all multifamily dwellings and then providing city staff with replenishment for those dwellings over time. Best practice overall in the industry. One of the elements that we did negotiate with Recology and they brought to the table was a need for growth in the routes that they operate. They currently operate around 6.5 routes in town and need 7 due to the growth in the community and the anticipated growth moving forward. One element here that also has been addressed, and you will recall earlier this year, you amended the agreement with Recology to address the impacts of the Chinese national sword policy, which has caused a bit of a crisis in the recyclables commodities marketplace, both resulting in a reduction in revenues that come from the sale of recyclables and an increase in recyclables processing cost. Via this agreement, Recology would still be providing and would be the first line of defense for the city in finding a home for processing those recyclables. But should the city find a better alternative that it wished to use, you have the right to redirect that material at your discretion. And then finally, we're able to get better reporting from Recology. This is mostly a cleanup item due to the fact that there are increasing state mandates and state laws under which the city has reporting requirements to the state and needs information both from Recology and from Mission Trail Waste Systems. Now, in terms of the financial impacts, this table shows that the top line is the current unit per month amount paid by the city to Recology for the recycling services they provide. And then in the columns below, what those amounts would increase by over the course of the first 3 years of a new agreement should it be approved. And you can see that the percentage increases are above 10%, but the overall increase on a per unit per month basis is relatively minimal. And I'll show you a couple of slides in a moment that indicate the comparability of these figures to the marketplace. After those first 3 years that we indicated on the prior slide, escalation to Recology's compensation would be tied to an external market index posted by the Bureau of Labor Statistics. It's a CPI that's more appropriate for a utility like a garbage company or water and other sewer utilities. National index, and over time, essentially, as that index changes year to year, so too would their compensation. That index changed, or is at least proposed to change from the current index, primarily due to the fact that the current index does not keep pace with the increasing cost of operating a solid waste operation such as this one. There is also a proposed change to the compensation methodology with Recology, moving away from what is currently a per unit rate for the units they serve, that in reality results in very little fluctuation month to month. So instead, what we've proposed is a methodology that's actually in use in many of the contracts that Recology has in San Mateo County, which is a fixed annual compensation, and that amount would be escalated year to year as described previously. This will make it easier for the city to administer and plan for the expenses under this agreement, and then also just more reflective of the reality of what happens with their compensation. Now, in terms of the reasonableness, we show that there is a bit of an increase that's needed. There are some good reasons for this in terms of capital replacement and the fact that operating expenses haven't kept pace, or sorry, CPI hasn't kept pace with the rate of increase in operating expenses. So there are some increases seen to their compensation, but overall, the per unit amounts paid are quite low. So they're at the end of the 3-year period that I showed on the prior tables, their per unit per month amount of compensation would be on the order of $6.48, shown in green on the far left side. And that compares to, in the next 4 bars over, escalated amounts, CPI escalated amounts from the prior bids that the city, or the prior proposals that the city received when this was competitively procured back in 2008. And then on the right-hand side, those last 2 bars are actual comps from the City of San Jose, which recently adopted contracts. It's been escalated for 3 years to project a future impact, and actual comps from the South Bay Solid Waste Authority, not including recyclables processing cost. One thing we should note, and we already mentioned that you as the council earlier this year authorized a change to Recology's compensation to compensate for the impacts of the national sword on the recyclables revenues. We have made an artificial adjustment of 5% to all the blue bars here to indicate what that comparability would look like. We do know that this is an impact that's facing all solid waste operators within the state and beyond. We believe this is a reasonable adjustment. Overall, it just shows a favorable compensation rate for Recology as negotiated. Moving now to the tentative agreement terms with Mission Trail Waste Systems. Similar term, coterminous for similar reasons in terms of amortizing capital investments over a longer period of time, therefore requiring lesser increases in compensation in the near term. That would result in new compressed natural gas trucks on the streets. Mission Trail Waste Systems currently operates compressed natural gas, so this would be a fleet replacement. It is due at this time. The others will have exhausted their life by the end of the agreement. One important benefit for the city is that right now, if you're a homeowner or a business owner in the exclusive franchise zones within the city and you wish to order a large debris box bin because you're doing a cleanup or you're doing a construction and demolition C&D renovation in your home, you call the city contacts Mission Trail, arranges for the service, and then there's a billing reconciliation between the city and Mission Trail because the city does the billing. Via this proposed set of terms, Mission Trail would provide the billing. Customers would call Mission Trail directly and have a direct line on getting their service arranged for these debris box services, which will both make it a more seamless transition or a more seamless customer service experience and also eliminate some redundancies. So it's more efficient overall. Additionally, within that, Mission Trail would be bringing the construction and demolition waste to a new facility or a facility other than your existing facilities that are currently used to achieve a higher rate of recovery and recycling on those materials, helping the city meet its requirements under state law. Another benefit secured is a new dedicated program manager position, an employee in the company that would serve as an education and outreach manager, conducting outreach and education, working with city staff as a compliance liaison, and providing the necessary reporting. The company doesn't have a dedicated position like this now to the city. It is something that is indicated as needed moving forward, especially in light of the new state requirements and increasing state requirements. Next bullet there, the on-call bulky item program. This would be a program wherein residents within the community could call Mission Trail Waste Systems and request an on-call bulky item pickup, similar to what Mission Trail customers in Los Altos receive. This would be a pay-as-you-throw system, so it would initially be at cost, but with the opportunity, at cost to the ratepayer directly. There's an opportunity, and we would structure the language in the resultant agreement, should you approve us to proceed, to allow the city to secure that for all customers on, say, a regular annual basis, included within the overall rates that they pay, so meaning at no additional cost. This could be an alternative to programs in the future and allow for new options for removal and disposal or recycling of additional wastes that don't get put out in their weekly setouts. To a similar effect, we've also secured up to 130 cubic yard boxes. Those are the long boxes you see on the streets for construction projects. Those could be used by the city to conduct additional cleanup campaign type events in areas not currently serviced by the cleanup campaign, or for disaster debris or other types of services at the city's discretion. It's simply the ability to direct those materials and to have that collection capacity that you don't have today. And then for the final two bullets are essentially in alignment with what I already described with Recology, more reporting in line with state laws, and a similar CPI adjustment mechanism using that water, sewer, trash CPI index that I referenced previously. Now, there are two options, as has been mentioned already, that we're seeking your direction on tonight. Option one would be a citywide rollout of the pilot program that was the split cart, garbage on one side, food scraps on the other. Only this would be food scraps plus food soiled paper, pizza boxes, and the like, items that currently aren't accepted in the program, so an expansion of the service. This would essentially replace the garbage container for all single-family residents in townhomes within the community. Option 2 as an alternative would be for residents, whether single family or townhome, to put their food scraps and food soiled papers into their current green cart, where the clean green material yard waste is currently put. The effect of this would require the 22% of residences, single-family residences that are in townhomes and don't currently subscribe to the Clean Green to actually do so. So there would be a hit to the townhomes as a result of option 2. There is a possible third option, and it pertains to the direction that staff is seeking about moving forward with green waste recovery on negotiations of mixed waste processing. That's shown here on the bottom of the slide. This option, different than options 1 and 2, would keep food scraps within a garbage container at a single-family residence or townhome. It wouldn't require the split cart program. It wouldn't require townhomes to have an additional third green cart. And essentially all of the contents of the black cart would go to a processing facility for removal of the organics and subsequent composting. And I'll show you towards the end of the presentation relative comparables for what the expected ratepayer impacts are of each of those 3 options. So just to reiterate, staff is seeking direction tonight about whether to move forward to potentially secure an option 3. It's not currently available. It's just a possibility. Now, in terms of emission trails compensation increases for each of those options, these are the results that we've been able to secure. You can see for option 1, it does require the least amount of increase to their compensation to cover new equipment and new assets. Option 2, slightly more of an increase over the course of time. And then option 3, a higher increase yet. And again, we'll show estimated rate impacts of all of these options towards the end of the presentation. We covered the residential food scraps, and just on the residential food scraps, the reason we're looking at those 3 options is because of the short-lived climate pollution, SB 1383 regulations requiring getting organics out of the landfill. You do have to implement food scrap and food soiled paper recovery programs, both for residential and commercial. We've covered residential. For commercial, you have 2 options that have been identified. One would be rollout of a third organics green cart to all commercial and multifamily dwellings that are required to subscribe. Some may be exempt, but many will be required to subscribe under state law. That would be both an additional container for most customers. Customers can voluntarily sign up for that program now. Some have. This would expand the reach of that. They would have an additional container and pay an additional rate for that, albeit they could potentially offset some of their garbage container size if they subscribe to an organics container. Option B, like the prior option 3 for residential, would not necessitate that additional third cart. It would simply mean relieving any organics within the current garbage containers. That would go to a processing facility to remove the organics and subsequently compost them. And I'm going to hand it back to Dave to cover the possible option for the mixed waste processing.
Thank you. Thank you very much.
All right. The short-lived climate pollutant regulation compliance can be attained by processing the contents of the garbage container to remove organics prior to landfilling. However, at this time, we do not have access to permitted mixed waste processing through our agreement with Republic BFI. So in order to present option 3 for the residential sector and option B for the commercial multifamily sectors, we would first have to secure mixed waste processing service. So as we stand right now, it's not a viable option until or if we are able to secure that mixed waste processing capacity. We've been looking for this for quite some time. We've been talking to local service providers, and ultimately we did send out a request for information to see what companies may be interested and able to provide mixed waste processing services. We did receive 4 responses on BidSync. One from PGL Holdings LLC. It's a company related to Mission Trail Waste Systems. They've secured land in Santa Clara to construct a new site, but they don't have any permits and would have a lot of work in front of them to clear the CEQA and get the necessary permitting. According to their submittal, they would not be ready to process waste until at least 2025. The short-lived climate pollutant regulations they take effect in 2020. Cal Recycle has made it clear that they will begin enforcement January 1, 2022. We also received a submittal from Waste Solutions Group of San Benito, which operates John Smith Landfill in Hollister. They currently have no permitted mixed waste processing capacity and did not identify any plans to attain it. We also received interest from Waste Management of Alameda County. They operate Davis Street Transfer Station in San Leandro, which is 33 miles away from Santa Clara City Hall. It's outside the 10-mile travel radius that we've agreed in our tentative agreement with Mission Trail Waste Systems to honor the pricing that's in the tentative agreement. They also would be relying on pending commitments from other jurisdictions to expand their permitted capacity. The earliest they would be able to begin processing the city's garbage according to their submittal is in 2023. Finally, we received interest from Green Waste Recovery. They operate a material recovery facility on Charles Street in San Jose, which is 5 miles away from Santa Clara City Hall. They're in the process of permitting an expansion to enable them to begin, that would enable them to begin processing the city's garbage by 2021. They also have a sister company, Zanker Recycling, which provides composting and construction demolition debris recycling services. And if we were to enter into negotiations with them, it's also an opportunity to secure disposal services after Republic Services and BFI contract expires December 31st, 2024. So with that, I will turn it back over to Garth. He's going to cover the estimated rate impacts to customers.
All right, thank you.
Almost through. I do want to be clear. So I have 4 slides showing estimated rate impacts. And before I go into those, I just want to clarify that, in the city, you have rates that are decoupled from the compensation paid to the company. So the city arranges for compensation terms with Recology and Mission Trail Waste Systems and Republic BFI for the services that become your solid waste collection and disposal and processing and recycling system. You then, in turn, look to the ratepayers. You set rates and charge revenues to be able to pay those expenses. So the companies don't collect the rates themselves. The city sets and bills those rates directly. And we don't have a rate study completed. We have a plan to complete one early in 2020, pending the resolution of the matters that are before you this evening. That said, we have prepared estimates for the purposes of comparison of these alternatives. These are high-level comparisons. They're based on the current best available information and also are meant to be conservative and represent the highest rate impacts that we know given the information that's before us. So I'll cover first the single-family 32-gallon small container-sized residents. These are the most common residential subscribers within the city. And as you can see, option 1, which is the organics in the split cart, would have the lowest overall rate increase over the course of these several years, whereas organics in the clean green container would be slightly higher, and organics in the garbage yet higher still. And that's relating both to, this encompasses the compensation increases anticipated for Recology, the compensation increases negotiated with Mission Trail Waste Systems for each of these, and then the resultant changes to what materials would go where and to what facilities at what per ton cost. It's inclusive of all of the services that ratepayers receive. That's what's shown in red below. So this is the net monthly rate estimate that would go to the ratepayer starting in those years. And we do have, of course, the current rate there for comparison. Now, for the 32-gallon townhome rate estimates, we see a similar trend for the organics and the split cart, but because for option 2, there would be a need for the townhome customers to subscribe to the Clean Green service, to have that alternative for their food scraps and food soiled paper, they would see a significant impact in their rates via option 2. Option 3 in garbage is similar to the prior slide. I should note overall that all agencies in California are dealing with the issue of how do they establish programs that are going to be compliant with the SB 1383 regulations. All agencies will be considering programs like these if they haven't done so already, and there will be commensurate type rate increases for complying with those programs because they are new programmatic requirements unfunded by the state. Moving into the commercial rate impacts estimates for option A, wherein commercial entities that currently have just garbage and recycling would need to subscribe to a third organics cart. You can see what the anticipated conservative rate impact would be. I do want to note here that this could be less than shown if those subscribers are able to effectuate reductions in their garbage service. That could bring this rate down, but it means that they have to really participate correctly and well, and that takes due diligence both on the part of the hauler, who would be Mission Trail in this case, and on the city. So these are conservative estimates. It could be less than shown if folks are able to offset adding a green container with a reduction in their black container. Via option B, there would be no need for a third container, although subscribers would still be in a position to voluntarily subscribe to that. That has been what we've arranged with Mission Trail via the tentative points of agreement. They could still elect to use the higher best use program in the SAFE program, but those that could not or would not, they would then have their containers processed and at the rate increases estimates shown. Similar story for multifamily overall, slightly different estimates based on our assumptions about the sizes of containers that would be used. Again, for option A, the impacts could be less than shown if those if those subscribers, those multifamily dwellings, were to offset their garbage rates as they added organics rates. And then, of course, option B is just the same program of shipping the black bin contents to a processing facility to remove the organics. And with that, I will hand it back to Craig.
Thank you.
So that concludes the bulk of the presentation. And so what I wanted to do now is just kind of tie it back to the first part of the presentation when I spoke about what we're requesting from council tonight. So before you are the first two recommendations. And so what we are requesting, and the first one is simply, we've worked with Recology. We want to move forward, finalize that agreement, and bring that back to you. That is a pretty straightforward one. The next item down there, which deals with alternative 3 or 4 in your report, that's where we're asking council to make a decision tonight on the option 1, which covers the split cart, or for the food waste, or option 2, in which the food waste is put in the clean green container. So we are asking council tonight to make that decision, and then we can move forward with finalizing those terms with Mission Trail Waste Systems. Then this last item here I wanted to focus on, you heard a lot about the potential for an option 3, and so we have not yet begun to negotiate those terms, but what we're requesting from council is for us to be able to move forward and you authorize us to proceed with negotiations with green waste. And so if that does not work out, then we already have the options that were decided tonight, and we'll continue along that path. But if we were to be able to reach some sort of agreement with green waste, then we would be able to come back and discuss that with you at a subsequent meeting for a different alternative. So that summarizes, and then obviously we're here for any questions.
Thank you, Director Mobeck. I'm going to start with Councilmember Hardy. Back on the council.
Thank you. Being the only council member that's been in the pilot area for this split bin, I have lots of thoughts. My first question is, my understanding is we're being asked to extend recologies for the blue bin or recyclable. My understanding is Recology does do residential garbage and organics. Was there any conversation, or did we look at them as an option as well as Mission Trail?
No, we did not. At the November council meeting, we were directed to enter into successor agreements for Recology for the residential recycling program and Mission Trail Waste Systems for the exclusive franchise, which covers residential garbage, clean green, as well as commercial garbage, organics, and recycling.
Okay. Also, I noticed that if we go with the Mission Trail, one of their options, and stick with them for our commercial, we're talking about looking at clean green in the short run for possible commercial and multifamily, but they talked about their parent company, PGL, having a site in Santa Clara up and going in 2025. Is that part of the discussion to possibly bring down those costs for for being able to mix the waste and have that separated?
We've not had any cost discussions regarding a potential future mixed waste processing facility in Santa Clara. The fact that it cannot be ready until 2025 leaves us in jeopardy of being compliant with the short-lived climate pollutant regulations set forth by Senate Bill 1383 that they were required to implement programs, and the statewide goal is a 50% reduction by 2020 from 2014 levels and a 75% reduction by the year 2025. Cal Recycle has made it clear in the draft regulations that they intend to start enforcing January 1, 2022, so that leaves us vulnerable to enforcement.
Is there a possibility of, if we go with proceeding with green waste, that we do that on a short-term basis so we still have options down the road within 10 years?
We could, there's any number of potential options would be on the table with green waste recovery in terms of term. Generally speaking, the longer the term, the better pricing you're going to get, and the more material that we would be able to provide to them, the better pricing you would get. But we haven't had those types of conversations yet.
I know that we've had some problems with our annual cleanup because of the runoff that occurs often, especially if it rains during that period of time. And I noticed in part of the conversation with Mission Trail, there was a possible change in the annual cleanup where we could have a one-time pickup. If I remember right, it's over $6 that individual residents are charged monthly for that annual cleanup.
So the monthly charge for the cleanup campaign, I believe, is just short of $6 a month. We're putting that, we've negotiated that option, and the tentative agreement with Mission Trail is an option for moving forward. If council were to direct us to come up with an alternative to implement in lieu of the cleanup campaign, that could potentially be substituted, but it was not put into the agreement with the intention of replacing the cleanup campaign immediately, although it is there for a future option.
So you're saying we could have a phase-out type situation where people would have a one-time pickup sometime in the year that was maybe more amenable to their schedule, and we would have less problems with our runoff?
If I can jump in, Dave Rowe, Manuel Pineda, Assistant City Manager. So as part of this agreement, we are creating that option, which could provide flexibility in the future. However, staff's not proposing to change the cleanup campaign, and that would be a policy direction that the council would have to provide. With the agreement,
for that clarification.
So just with the agreement, could gives additional options to the community, but definitely that would definitely be a policy direction. We are planning to continue with the cleanup campaign.
But we would have those open. We would have some of those options within what we are talking about negotiating.
Yes, that's correct.
Also, the other problem has been the infrastructure of the carts and the fact that the wheels have come off, they've fallen apart, and the infrastructure is too heavy. I know a neighbor of mine who's in her 70s, it greatly increased by double the weight of the cart even empty. So would part of this also be those of us who've been in the pilot part be part of this redesign of something? And you mentioned that you could put pizza boxes in these now?
Let me take that in two parts. So
Okay.
if council were to direct staff to negotiate, with Mission Trail for option one, the expansion of the pilot food scrap recycling program, all participating residents, including those in the pilot area, would be provided with a new split cart. We acknowledge that there's been durability issues with the containers that have been out there, the wheels mostly, with the divider. We would have to work with Mission Trail Waste Systems to provide an alternative. We haven't gotten into those conversations in depth at this point because we don't know that we're moving forward with that. But before we deployed citywide, we would want to see what some of the new prototypes look like and test them out in the field in the pilot area before launching those citywide, because those whatever would be the replacement, as far as we know, isn't out in service anywhere else. So we would be the first, and we would want to see how something like that worked.
Thank you.
Councilmember O'Neill.
Thank you. Thank you, Dave, for the report, and also Bart and the whole team. So one of the questions I had, first of all, if we did the split cart where people are putting whatever organics they've got at their, at their home into the container, then does that eliminate the need for mixed waste processing?
So depending on which sector, so if you're talking about the split cart just for residential would not need option 3 for mixed waste processing. However, that doesn't address the commercial business and multifamily customers that have mostly shared dumpsters. They would not be getting a split cart in option A or B.
Mm-hmm. But so how effective is I'm just curious, because I just have a hard time imagining that separating out organics at, or at some other location, or, that there's more of a, in terms of we're supposed to be doing this to lower our carbon footprint. Is there data on which of these methods is actually, helps us in that regard? And that doesn't even take into account, like some of the distances that have to be traveled. But what do the studies say?
So we don't have any data on, as it would apply to us, on what the carbon footprint would be to each option. We don't necessarily know where all the end markets are going to, but empirically, the food scrap recycling is likely, it's considered the better and higher use by EPA. But we don't have that kind of data on the full carbon footprint if you take in collection and where they're taking it to processing, where the residual would need to go. We don't have that analysis.
Okay, so if we were to talk about moving to green waste, so does that mean that we completely end our contract with Republic BFI, or not let it lapse?
So we would fulfill our obligations in the green waste the Republic BFI contract through December 31st, 2024, whereby we would take all garbage to be landfilled, which includes the residual from either the pilot food scrap program or the residual from mixed waste processing. There will be residual from both that we're contractually obligated to take there. We would also continue taking our clean green over to Republic BFI for composting through 2024. So,
But after that, when the current contracts expire, we'd have to, if we're looking at green waste, we'd have to take everything there.
Not necessarily, depends on what we would negotiate, but it is an opportunity to gain long-term processing and disposal, if that's the direction that, you direct us to go, and we're able to negotiate those terms. So that would provide us additional security after 2024 potentially.
And that would include all those many truckloads of stuff that people throw out during cleanup month?
Yes, they could potentially process cleanup campaign debris as well.
Okay, let's see what else I want to ask. So when we look at, so you do say, like, one of the things that on the rate increases, you do talk about that some of there's a number of components to that. When we look at that rate, it's not just it's not just the vendor costs, it's a lot of costs that are bundled into that.
That's correct. There's the collection costs that we're paying the collectors like Recology and Mission Trail Waste Systems to pick it up. And then there's also the processing and disposal costs, that we would be paying Republic BFI to either landfill it or compost it. The processing costs aren't the same for all. So generally speaking, the more processing that you have to do, the higher the cost. You pay for the convenience. So mixed waste processing is the highest on the back end processing costs, where landfilling, unfortunately, is the cheapest way to get rid of stuff right now.
Okay. And you mentioned that green waste, which is in San Jose, is that the final? That's not where they actually the end product goes, is that?
No. So if it were to be processed through their San Jose facility, they would pull the organics out. The organics would be taken to their compost facility, which I believe is Z-Best, which is in Gilroy. The garbage residual would then be transported to Republic BFI for disposal in the landfill.
Is that, Newbie Island?
Yeah, that's Newbie Island.
Okay, so green waste would also take it to Newbie
Yeah, we
Island.
would have to make that arrangement stipulating that all residual goes to Newbie Island, because we're contractually obligated to take all of our garbage there through December 31st, 2024.
So you mentioned the permitting process, because it looks like, right now with all of our options, we've got a gap period that we're trying to comply with. So how certain are we of where green waste is in their part of in their permitting process? Or, do they have a whatever kind of facility under construction that they would need?
So that they have Green Waste Recovery has an existing facility, my understanding, and then they're here and they may comment later, that they do have, their CEQA is complete. So they're much further along in the permitting process to do an expansion. So to basically increase their permitted capacity to mixed waste process. So staff believes that they are the closest to getting us to compliance.
Okay, thank you. That's all I have for now.
Thank you. Councilmember Watanabe and then Chahal after that.
Thank you, Dave and Craig, and for the presentation. This is hard. It really is. And I know Dave knows recycling, and he knows about waste, and I hear you talk at the recycling meetings, the county recycling meetings, and so I know you know your stuff. So, but I'm glad that you're close to it. Well, at least a tentative agreement with Recology. I think they do a really good job. Regarding Mission Trail, and I was really glad that this came up, the tentative agreement that has been proposed. And I know we talked about it, that, having the new, the on-call bulky item collection program, and I think Councilmember Hardy alluded to the fact that it could possibly be in lieu of the annual cleanup campaign, if that's how council wanted to go. Because as I told you, Rivermark does not have that, the luxury of cleanup week. And we don't pay for it either, but at the same time, I know that that would definitely be, an incentive for people out there, because they're always looking for ways to dispose of items. So I like that addition to the tentative agreement that you're working on with Mission Trail. Regarding the, they have the organic program that they currently have with the food scraps, and where they take it to safe. If we decided to change, if we decided not to go with Mission Trail, what would happen to that SAFE program? Will we still have the option of using it? Would it still be a source of, disposing of organics?
So there's kind of two components. There's the residential and the commercial. So, say for instance, you selected to go a different direction for both. The contract's structured such that Mission Trail would still be able to sell their commercial contracts, the commercial customers, the food scrap recycling program. That they would really have to work with the customers and provide a lot of technical assistance to be able to get a corresponding reduction in garbage service to make it worth its while. But on a commercial front, they would still be able to market that program, and for high volume food generators that could actually make corresponding reductions in garbage service, it may be financially viable and worth their while to participate in it. For residential customers, if you were to select either options B or C, there would not be any additional opportunity for the residential customers to participate in the SAFE program. But so I guess what I'm trying to say is they're two different sectors, and you could potentially have, option one for the residential and option B, the mixed waste processing for commercial and multifamily. So it doesn't all have to be the same. So it would depend on what you chose.
Good, I'm glad you brought that up, because that was one of the things that I was thinking about, because I think the SAFE program I think it's wonderful. Councilmember O'Neill and myself have toured it twice, and we're both very impressed, and took some of it home to my dog, who absolutely loved it, and so it's definitely a good product. But I'm glad to know, I mean, if we have some options where we could do the mixed waste processing of garbage, and give that to somebody else, like the commercial and the multifamily dwelling units. If we have an option like that, I like that. And so just so is that we just cover everybody that needs to have their garbage removed, but at the same time still be in compliance, with Calorie Cycle, and moving forward as well when the deadlines come due.
And all three, we believe that all three options for residential and both options for commercial and multifamily will gain us compliance with the SB 1383 regulation. So all three of them should be, we believe, are going to be compliant.
Okay, thank you.
Member Chahal.
Thank you, Mayor. Thank you for the presentation. I just have one simple clarification on the option one. One of the biggest complaints for the pilot program was that residents were losing the actual garbage capacity. So I would like, during this negotiation process, we safeguard the garbage capacity for, if we go with option one, so that 32 gallon has 32 gallon of actual garbage capacity, and plus additional food scraps. So if we can work out on that, that would be good. Otherwise, from efficiency point of view, I think option one makes much more sense than other options. So can that be part of your negotiation with
So on the containers so we have for residential 20 gallon, 32 gallon, 64 gallon, and 96 gallon customers. So I know that we could preserve the garbage space in the 20, 32, and 64 gallon for those customers. I don't know that that's possible for the 96 gallon customers. I haven't seen it because currently we're using a 96 gallon cart. So I don't, unless you're really making a much larger container, that could be problematic. Or, you know, the other option would be potentially adding a second container for those customers. I guess, you know, I would just caution that, you know, we are required to implement these programs. This short-term climate pollutant regulations do have terms in there that require, you know, the city to have active enforcement. If you aren't reducing the garbage side of the container, we're not really incentivizing folks to change behavior and start separating out the food scraps. So you know, if the state's not coming close to their reduction mandates, it is in the regulations that we are required to have a very robust enforcement program. And, you know, that by doing that, if we're not changing enough behavior by, you know, taking away some of the garbage capacity, there is a possibility we will have to implement a fairly robust garbage enforcement program later down the line.
Would we be getting some data feedback, like how much is the food scraps we're processing versus in one option or the other? We will be getting a regular feedback from all these vendors?
So I do get monthly reports from Mission Trail Waste Systems, you know, that documents how much food scraps we're getting. I don't remember, you know, on a monthly basis how much it was. If I recollect from memory, you know, with averaging about 8 pounds per container per week. I'm not positive if that was correct, but that would be the closest estimate I could give you right now off the top of my head. But I could get that information to you. I do have it.
Yes, okay. Thank you. Thank you.
Okay, are there any other council questions? Okay, seeing none, staff, did you have any other comments before I go to the public? Thank you.
Just had one.
Yes.
I just realized I did not answer part of Councilmember Hardy's question on pizza boxes. So currently in the pilot food scrap recycling program, we're not set up to take the food soiled paper, which includes the pizza boxes. However, if we were to expand the program citywide, we would include food soiled paper, napkins, pizza boxes. So sorry, I didn't address that the first time
That was
around.
important. We all eat a lot of pizza, so.
So do I.
That's an important question. Thank you. All right, seeing none, I'm going to go now to the public to make any comments on this. Linda Nepper, you'd like to come forward, please? And I don't have any other cards after that, so if anyone would like to speak, they can just queue on up. Good evening.
Good evening. I did try and visit Recology for a field trip and for interest and got stonewalled. And so I'm jealous that people managed to get there. Citywide garage sale, I really like and recommend. And what I do personally is I put a big free sign and like 3/4 of the stuff goes away. So I don't have to dump it later. But with the split cycle, or the split bins, I really don't like them. And the reason why is because I've seen a variety of people use both sides for trash and stuff them in. The scraps is usually, if you think of a milk carton, a gallon of milk, that's 8 pounds. That's how much is average waste for organic waste. And yet you're taking half of the bin to do that organic waste, and then you're too much else. So of course people put things in the side that they shouldn't put in. So I don't like the split bin at all. I would like them to have a separate side for organic or people compost, except for the meat things. And let's see, I think that's, for, when I looked at the numbers, it's 100% increases for the townhouses, but that brings them even with the houses. It's not like they're suddenly paying a lot more compared to the houses. And that's all.
Thank you, Linda. Anyone else? Please come forward if you'd like to speak. It's open now. We have two more? Oh, so sorry. Louis Pellegrini snuck that card in there. Welcome.
Good evening, Madam Mayor and fellow council persons. I'm Louis Pellegrini, one of the principals of Mission Trail Waste System. It's been a pleasure to be a service provider here in the City of Santa Clara in my tenure since 1998. We feel proud to help the city meet all the mandated goals and provide a level of service that the residents deserve. I want to compliment the city staff on the negotiation process. I know there were some priorities, and I think priority number 3 was minimize haulers' profits, and I think us haulers in the room can contest that the city's been doing a good job trying to do that. So, which we respect. Trying to clarify some of the questions and comments that we've heard here tonight. In the staff's original presentation, a lot of things were clarified in my mind during the presentation here tonight, so I won't delve into it too much. We're in agreement on most of the things presented. A few minor details on our proposal for option 1, 2, or 3 includes processing cost of the organic stream that we would be handling under option 1, and also includes the processing cost of the recycling we would be collecting in our commercial recycling services here in Santa Clara. I think it was defined a little different in the process. On the overall cost represented that the ratepayer will be paying for the different options, it represents a 44% increase in 2020 over today's current cost. Out of that 44% representation, and I appreciate it's an estimate, Mission Trail's part, my estimation is about half of that for the services that we're going to provide. In looking at that option 1, which is basically the split cart option, staff's documents also reflect it's the lowest cost option and substantially lower than the option 3 as an alternative under negotiating with Green Waste. We have a little concern, and was spoke tonight by staff, that on the commercial and multifamily, these numbers might be on the high side, and we're in agreement with that. When I look at all the numbers represented here, option 1, split cart for residential and continuing the organic diversion through Mission Trail services, is still the lowest cost option. Extrapolating on the numbers that represented here, I believe in a single family is over $1.5 million savings to the city overwide than option 3.
Thank you, Mr. Pellegrini. Thank you very much. Emily Hansen, please come forward. Good evening.
Good evening, Ms. Mayor, members of the council. Emily Hansen with Green Waste Recovery. Just give you a brief overview and then address some of the questions that were asked this evening. So Green Waste Recovery is really excited to be able to have the opportunity to enter into negotiations for the mixed waste processing. Originally, we had started discussions just on the commercial side, and through the RFI process that was issued, we were able to integrate both the commercial side as well as the residential side and offered a discount on the pricing in the event that you opted for option 3 and option 2. Option 3 on the single family, option 2 on the commercial and multifamily. We do hope that you will entertain and support the recommendation to enter into negotiations. As your staff said, that will come back to you for decision no matter what, so we kind of figure what do you have to lose. I did want to address Councilmember O'Neill's questions, two of them specifically, and one of them was about the recovery rate when the garbage is actually processed. So when that material comes to our facility in San Jose, it's actually a little different than Mr. Staub represented, not by any fault of his own. We take in all the garbage, we remove the recyclables, and then we also remove things that are non-compostable, non-recyclable. Everything else goes down to compost. And so we're not just picking out the apples and the other organic matter, we're actually picking out the cans, we're picking out the tennis shoes, and everything else goes down to compost. So there's a very high diversion rate for that material. The second thing that I wanted to address in terms of the readiness to be able to provide the services, we've been operating our composting facility, our sister company has, since really the 90s, 1990s, many, many years ago. And what we're doing down there is just simply an expansion of that. So our permitting status is very close to the final frontier, and we know that we'll be ready and able to provide those services in 2021. So thank you.
Thank you very much. Any other member, please come forward. Good evening.
Good evening. I'll fill out card. My name is John Zarelli. I'm General Manager for Recology. Mayor Gilmore and members of the council. Recology has enjoyed a 20-year partnership providing recycling services for the residents and businesses, residents in the city of Santa Clara. For you that may not know, Recology is 100% employee-owned. We look forward to continue our partnership under the new agreement and the savings that the City of Santa Clara and the residents have enjoyed for the last 15 years. So thank you.
Thank you. Anyone else? Nobody else? Okay, Councilmember Davis, your light's on.
Thank you, Mayor. Thank you for all your testimony, but I got to tell you, I did my little survey on my street, and they hate the split carts. They just really hate them. But anyway, that's for the people that have them. And I'm under the understanding that they might be changed and better equipped. Is that what you said, Dave Staub, instead of things falling apart and having issues with them? Because launching to the whole city, there might be pitchforks. I'm not really sure how that's gonna fly. But, and I understand that we have to do this and we have to engage in recycling. So I wanted to make a motion to direct staff to finalize the terms with Recology, alternative 1. And then on alternative 3, you have an option. Okay, so then alternative 3, direct staff to finalize terms with Mission Trail Waste Systems for exclusive agreement for collection, transportation, garbage, organics, commercial, recyclables. And I don't know if I'm gonna get screamed at for this one, but I think maybe we should expand the existing split cart thing, even though there's a lot of people that hate this idea. But if you are willing, Mr. Pellegrini, to fix those carts and have a good, robust education system, I think we'll be able to get that one through. And last but not least, listening to green waste, I would like to recommend option 6 for staff to enter negotiations with green waste recovery for mixed waste processing, recycling, transfer, and disposal services of garbage, organics, commercial recyclables. If negotiations are successful, you've got it. So that is my motion.
Second. Should there be a clarification? Because I heard almost 2 different things on there.
No, following.
Is that correct?
Yes.
So you voted for split carts, but then you voted, your motions for split carts for the whole city? And
it
then
says
you're also
expansion of existing pilot split cart food scrap program.
So isn't the alternate 6, maybe I'm not understanding, does alternate 6 mean that we don't have split carts? I'm just asking staff for clarification. Does alternate 6 mean we don't have the split carts
So-
and we pay? So just can you explain, because
Sure.
I'm confused
So what
now.
alternate 6 would allow us to do would go back and talk with Green Waste to see if there is a viable option to do the mixed waste processing with them. If there's not, then we would, come back and let you know that, and we wouldn't move forward. If we're able to negotiate with them and arrive at some deal we think is beneficial, then we would come back to council and say, hey, we've negotiated with Green Waste, here's what they have to offer, and then we can make a decision if that's going to go.
Okay, so we wouldn't have to do the split carts if we're doing that?
Potentially.
Because I'm not in favor of the split carts at all.
Yeah, it
So-
potentially
Mayor
gives
Gilmore.
you another option, but not guaranteed.
Okay.
I do want to clarify, though, that if you select option 1 today and we go to negotiate with Green Waste Recovery and are not successful, we would implement option 1 at that point.
Thank you.
So we would not come back at that point to revisit the item.
So does does this serve as the hearing to our community that if you don't come back to us, the entire community is getting split carts?
Ultimately, you will have to take action on an actual
There's
agreement.
one more
on the
time of
agreement.
action.
Yeah.
Thank you, because we
the
really
agreement.
need to, as you can see, thank you, Linda, for coming. We have one community member here, and I suspect that if we're taking action for the whole city, we're going to have a lot more people here talking about split carts. So I just want to make sure that we're voting, it will come back, because I just want to make sure if I vote on this motion, because I'm not in favor of split carts, but this motion will allow us to talk to
Let me add just one more thing of detail.
green waste recovery.
From a timing perspective, so when you provided us direction to do direct negotiations, we developed a schedule based on the fact that if we're not successful, we will have to go out for an RFQ. So the timing does get tighter. So if option 1 or option 2 is selected tonight, at some point, if we're not successful with green waste and that's no longer an option, one of those 2 options would have to be selected. And we want to complete negotiations for one or the other. If we have to go back and renegotiate because we have a change in option when the agreements go forward, that gets that time frame. If we have to go out for an RFQ, makes it a lot shorter. So I just want to make sure that that was clear
No,
to the
I'm
council.
still unclear with everything you just said, because I'm just wondering, with the public, are you telling me that if we vote on this and the green waste option isn't an option, we have voted for split carts for the whole city?
We would negotiate a contract for split card for the whole city, that's correct.
But then when do we do the public outreach on the split carts? So that has to be part of, we can't just make this decision in a kind of a void over here.
Could we do 1 and 6?
What they were
Can
asking
we-
for direction. Okay.
No, that's why I'm just making clear,
Okay.
is direction actually
Direction.
action? That's what it sounds like to me.
We would
Direction
have,
for negotiation.
yeah, we would have some meetings over the next couple of months and do some outreach associated with that.
Okay, that's all I want to hear, because I think the outreach is going to be a little bit telling to us if we're not able to negotiate with green waste. So, okay, thank you. So we had a motion and was there a second?
Raj.
Councilmember Hall. Okay, motion and a second. Here we go. Councilmember Hardy, Councilmember Watanabe, and Councilmember O'Neill.
So I'm glad you made that real clear. I am leaning towards supporting this because we have some options. Otherwise, I'm going to have to get a bulletproof car, and my porch light will get shot out by my neighbors. When I walked precincts, I got an earful about this program, and that's why I was very clear that there would have to be redesign. Major redesign and a really good outreach, because I don't feel that happened before, and there are some very angry neighbors. So I like that we are looking at some options, and the fact that we could have, because we would have a lower cost with the split cards, but we are putting a lot on our residents. Now, with the green waste, you still have to separate those compostables, because they would go in the green waste possibly. Or we could have the idea of them, I like the possibility of them going in with the regular trash and it gets separated out. I looked up and Placer County does it that way. And they feel like they get 100% recovery because of it. So I think we need to look at some options because the separate to put in the clean green would still require people to be separating things. There's your problem.
Thank you. Councilmember Watanabe and then O'Neill.
Thank you, Mayor. I too agree, you know, I mean, it's good to have options, but at the same time, I am concerned about the cost. You know, our residents, you know, bear the cost of so many different things, and frankly, I was leaning towards option one just because it was the cheapest. And I mean, right now, when you look at the garbage cans, on my street, we're not in the split cart program or the pilot program, but I mean, I see broken carts all the time. So I think no matter if you have a split cart or a regular garbage cart, they break and the city comes out, they replace them. But at the same time, you know, I think the tentative agreement that with Mission Trail about regarding, you know, possible way for, you know, residents that don't have cleanup right now, I think that's a really good option to have. And so I hope that, you know, going forward that something can be worked out. But at the same time, I'm glad we have options. And the other thing too, I mean, it's too bad that Mission Trail is not in a position to be able to get permits right now and develop a place closer to Santa Clara or in Santa Clara, because Councilmember O'Neill talked about it earlier regarding the carbon emissions and reducing our footprint. And I think that's a good way to do that by having it here in the city of Santa Clara. So anyway, good luck with your negotiations, and look forward to see what you bring back. Thank you.
Thank you. Councilmember O'Neill.
Thank you. I think that, you know, every time, you know, and I think people are a little bit weary of change, but I think the change is going to continue to happen. And if, you know, we're going to continue to live on this planet, we're going to have to make a lot of changes. And, you know, it wasn't too many years ago that, you know, recycling, I mean, who did, I mean, everyone recycles, or almost everybody, you know, recycles now. And I think there's a lot of other changes that we're going to have to be making in terms of our use of, you know, internal combustion engines and natural gas and just our use of plastic. I think, you know, that as I've talked to people, you know, and I've learned things that it's just because we throw it in the recycling bin doesn't mean that it gets recycled. And I think that's one of the those images of those huge ships full of our garbage that we've tried to send to Asia. Now they're like, we don't want it, you know, so we have to figure out what to do. So I think we're going to have to change a lot of things about how we live. And I would think that we can work on having a better cart, and hopefully as we become more food sensitive people, you know, we can't, you know, and I'm an offender too. Hopefully we won't have as much organics or like wasted food, that we're making sure that we're, you know, using food that we have reasonably, you know. So I urge people to be patient and let's work on the mechanics of it. Because I think if the residents can separate as much as possible, I think that will work better. And one of the things about also in the idea of being able to call for pickup of bulky items, I think that could be a supplement to the cleanup week. I mean, I'm not the hugest fan of cleanup week, but some people like it, even though I have more people that have come to me in the last year or two and said, can't we do something about cleanup week, because they're getting tired of some of the abuses. So, but even if we had cleanup week, I think if we have this program, you could call, like if you had an old sofa that you're trying to get rid of or something like that, that they would come and get it. You could pay, I'm sure pay for it, but that you would have option to that. And I like the idea of having some of the the containers, the large waste containers, that maybe we could put into some, you know, because we've done a little bit of work on helping some of our neighborhoods that could use a little bit of rehab, and maybe we could take more advantage of that program and help some of those neighborhoods do some extra cleanup to improve the quality of life in their neighborhood. I want to see us be able to do as many things as we can within our city. But you know, at this point, we're not, with all of these, we're talking about sending the staff to, you know, work on terms, and all of these agreements are going to have to come back. So I do believe that, you know, for all of them, we do need to do some outreach and use some of the tools that our communications director has been developing to promote, to help advertise, use all of those means that we have to help educate the public. And it sounds like Mission Trails, and I'm sure Recology, and all of these companies, I'm sure, have staff that can help us do that education. Because we're, as I said, we're all going to have to get educated if we're going to have a decent planet to pass on to the next generation. So I will support the motion.
Thank you. So I think everyone brought up an important point, is that we need to outreach to the public about what's in store. Many of you were on the council when we did the pilot program, and for some reason there wasn't a single council member that had the pilot program in their area. Now we have a council member, so here you go. And I do remember the public response to the pilot program. I still hear about it now. So we have to really make sure we talk to the public if we end up going that way with the split cart, because we had issues with our seniors and the compartment, and their garbage got smaller, but their bill didn't get smaller. I mean, I can go on and on about the, you know, the feedback that we got. So I want to make sure we have a really robust outreach on this before, if that's the way that we go with the split cart. Sometimes people like the convenience of putting everything in one bin, and then it's, you know, recycled to 100%, as we heard from Green Waste. And I think that's the goal, to make sure that all of the materials are diverted in the way that they should be. If that's the goal and that's the convenience, and you're paying, you know, maybe $4 a month extra, and this is what you have to do, let's hear from our community. What do they want to see? So I think we have to be very careful as we move ahead with this. We have great businesses here with Mission Trail and Ecology and Green Waste, and you know, we've had very good luck with our pickups here in Santa Clara. But before we take the big step, we need to talk to the public. It's obvious the public isn't here this evening. So I'm going to support the motion, not because I like split carts, because I don't, not at all. But I want to at least get the discussion going and look at our options for green waste too. So we have a motion and a second on that. Please register your vote. And that passes unanimously of those present. And thank you all for your patience for this item that came up later in the agenda this evening. And I know you'll all be back, so thank you very much. All right, next we have reports of members and special committees. Councilmember Davis.
Thank you, Mayor. The Triton Museum is having a Oktoberfest on, let's see, Saturday, September 21st from 1 to 4 p.m. Free admission. They will have beer and food for sale, games, music, and much more, and art. So I ask you to attend this event. And I want to say that I had a good time at the Art and Wine Festival this weekend. But, City Manager, we did have some complaints. The complaints are that the people that attend our lovely park for 2 days love to collect the mugs and glasses with the date on them every year. And we really are running into a problem with that. I don't know who to I guess I can complain to you, but we really need to look at that, because there was a lot of people that were trying to trade glasses, and it's one of those things that they look forward to, and that's one of our specialties, I guess, and we're falling down on that job. So Can you? Thank you.
Find out what happened, how many we ordered against sales, and report back.
Okay, thank you.
Thank you for that. Councilmember O'Neill.
Yes, thank you, Madam Mayor. Last week, I was able to attend my first full meeting as a board member of the Northwest Public Power Association up in Montana. And it was a very interesting experience. It's always really good to meet people from other parts of our country, particularly those in the western states. But even, it really makes it clear, even within California, we're on the coastal side, we're in the bigger cities, and what the needs and requirements of our fellow citizens that live in small communities. And so there were, representatives there from Alaska, British Columbia, Montana, Utah, Wyoming, Oregon, Washington, Idaho. So and it's one of the things that, like I said, there's a lot of differences, but everyone has a lot of desire to provide really good services, reliable services as cheaply as possible for their residents, whether they're a municipal utility such as ours or a co-op, or they even, in Oregon, they have what they call the People's Utility Districts, and, for the different cities. I kind of like that name. So we heard a lot about, once again, some of the issues, and what was really interesting was to hear people from, places that you wouldn't think would talk about it, but they were talking about how they are seeing the differences in their climate. And particularly, it was actually a little scary to hear some of the people from Alaska talk about what has been happening and the damage to their power systems as a result of wildfires. So I was honored to go there and represent Santa Clara, and I hope we can do some good work in the future.
Thank you, Councilmember O'Neill. Councilmember Hardy, and then Chahal.
We had our BPAC meeting, always fun, and you will be seeing coming down the wire the pedestrian plan. And we had a lot of fun discussions about very specific items, but the members are the eyes and ears and that are out there and have pointed out a few things, some specific concerns that we're working on. So,
thank you. Thanks for that. Councilmember Chahal.
Mayor Gilmore, is it the right time to make a motion to excuse Vice Mayor Mahan?
If that's what you want to do.
Oh, okay. Motion to excuse Vice Mayor Mahan.
I didn't know she wasn't coming, so. Lights on the motion. And that passes 4-2. Do you have anything else?
And I did attend Triton Museum Sikh Art Museum thing, and it was well attended, and the very talented artists were there, and this was arranged by the Sikh Foundation, and Assembly Member Ash Kalra was there too. It was a very well attended event on 8th, I think, if I'm not mistaken. Thank you.
Thank you. I know that Councilmember Davis brought up the Arts Wine Festival and the complaint. Yeah, I got those. I work in the glass booth. But I don't want it to take away from what a great event it was for the City of Santa Clara, and to see our staff members working so hard, our Parks Department, all the departments in the city to be represented out there, fire, police, everybody, SVP was out there. I saw many of you out there working, so thank you very much on behalf of the community. And it's such a great community event, and it's getting better and better every year, more people every year. We are not able to keep up with actual success of the festival because it was so busy, especially Saturday, that we pretty much ran out of everything, and even on Sunday. And a lot of the community groups, which really make a lot of their proceeds from the food booths and other things, they ran out of food. Everybody was running out, so it just shows the sign of a successful event, and that the community loves it, and they look forward to it every year. And our staff did a fabulous job in making sure that it ran smoothly and without incident. So thank you very much to
And they loved the
everybody.
music.
The music was great.
Kudos on the music. They were very, very happy about the music.
Everything. It was
Everything.
just really pretty fabulous event for our city. I'm really proud of it. So I just
want
want
to
to say.
thank the mayor and council
Yeah.
too for supporting the event. I saw a lot of you out there and saw on Facebook your presence. And so the support, staff feels it, the community feels it, and thank the mayor and council. We do have a quick video about the Art
do
and Wine
we?
Festival that we want to
Can
show.
can we see it?
I have a number
Yes.
of other announcements. There's
Yes.
3 note and file items, but let's get to the video since it's a feel-good item.
Okay.
I was going to say, it's good that the rain held off.
Sunday morning. Between the electric slide. Ben?
It was fun.
Great. I'll tell you, so many people said that of all the arts and wine festivals they go
have the
to, they
best.
love ours, and they love, because they really love our location with the trees and the hills and the
Layout.
water and everything else. They think it's great. So wonderful compliments for our city. That's a great video. Thank you. Thank you,
So we'll be-
Communications, for putting that together.
We'll be pushing this out, letting people know to hold the date for next year, September 19th and 20th of next year. And it's a good opportunity just to showcase the events of this weekend. And I just have a couple of other announcements, if you'll bear with
Sure.
me. We will be posting the public records log. I know that came up at the last meeting, for full transparency of the Public Records Act requests that we've closed, as well as those that are open. That will begin tomorrow, I believe. It's also National Hunger Action Month, and I just want to announce that the Santa Clara Library, together with the Santa Clara Unified School District and Second Harvest Food Bank, will be recognized by the County Board of Supervisors at the September 24th meeting. In total, we served 10,600 summer meals. We also provided a learning portion of our program that was offered through a state grant program. And I want to give a lot of kudos to our library staff for developing such a successful partnership and address food insecurity in Santa Clara. We've already acknowledged the 39th Annual Art and Wine Festival. I want to give a special thanks to all of our staff, police, fire, parks and rec, water and sewer, community development, and all the other departments, as well as the mayor and the city council for sponsoring and supporting such a really good event. And in true Santa Clara form, as I've learned, we're turning the corner and now focusing on the Champion of Parades, which is September 28th. Our Good Neighbor letter went out this week for those that are affected by street closures and crowds of spectators along the route. There are over 100 entries with over 2,000 individuals in the parade, including marching bands and hometown heroes. Also, please check out the latest bookmobile karaoke. The Parade of Champions organizer, Anna Vargas Smith, will be featured in the bookmobile. And also some good news as we continue to push for innovation. We have new service to instantly print your business license certificate online. You can now go online and be able to file and print out your business license. And so that's a new feature and service that we're able to provide. Those are my announcements. Thank you.
Great announcements. Thank you very much. I love that bookmobile karaoke. It's so fun to watch. Cody does a great job. City manager's next.
I don't think she can sing.
Doing it for the new year.
Okay, city manager, executive director report, response.
Those were just note and file items.
These are all note and
Yeah,
file.
no comments.
Councilmember Davis.
Yes, I wanted to kind of piggyback off of the city manager's report about the San Jose Spotlight article, but mine is just a little different. Mine is about the Mercury News. I would like to request the city manager to get a letter of explanation from the Mercury News about an article that was written where it says the Stones blast Santa Clara Levi Stadium, and that was on September 12th. But online, there was an article that was written, and it has created some issues because what was clear to me was the original article written online, there was a redaction done to get this. And I know that we have a problem with the 49ers, and basically it seems like it's the Hatfields and McCoys, because the city attorney alluded to the fact that there are tiffs and arguments, but this clearly, when you're going to do journalistic integrity, which I really would like to have an explanation from the Mercury News, it's important that when this was written, that the story alluded to the fact that it was about the curfew being micromanaged and we're dysfunctional. But 2 points in this article were redacted, so I want to know why. The first one is, it says, question if the 49ers solicited the letters from Morrison and Wozniak. Shondock reported they encourage and routinely get comments from followers and promoters alike. So that means that this story was solicited. Second, they took out of the paper, which I think was important, that the city manager received an email, but it said that the Metropolis has also questioned the team's management on other fronts. And then you went on to say that we had problems with worker wages and curfew and other other items. The stuff that was redacted was about the 49ers. It said the staff has hired a third get-together to review all contracts and has claimed it would problem again back to employees if wage violations are identified. The town also criticized Mercurio, the stadium supervisor, for self-dealing immediately after Mercurio disclosed he previously bought shares in 2 businesses that had to get the job done for the stadium. This was redacted. So when you get this story, and this story goes online, I think that our public and our city is owed an explanation from the Mercury News as to what are the facts. I mean, let's be fair. Let's, get both points out. But I had a staff member take the original online that was on September 11th, take the one from September 12th, and she put this together and showed me what was redacted, the word changes, how it was actually manipulated to get to this. So I don't want to make any calls on them. I just would like you to ask them for an explanation why we looked bad and other people kind of look good, but I just want to hear what they have to say. And I understand that when you go to print, that sometimes you have to condense. I get that. That happens in all reporting. But at the same time, you took out 2 very important points. Condensed. Yes, it was condensed on both. That's what I said. Yeah, I did say that.
I'm happy to take that information, and there's obviously a representative here from the Mercury News, and we can work on developing a response for the council. I do want to make a statement, though, about some of the information that you referenced. The 49ers don't like state laws. They don't like the state prevailing wage law. They don't like the public works procurement law. They don't like the state building code, and they don't like the state fire code. The issues that they have accused me about, as referenced in the article here, are issues of compliance with state building codes and state fire codes. I have no discretion to waive those. And nor does the staff that are here. and we have no discretion to allow to overlook them. I also want to state that just like we showed their paperwork and the quality of it tonight, that's the same way that their quality of paperwork came in for their applications, which in some cases were coming in 48 hours, 72 hours before the event itself. We have already shown and proven tonight the quality and how dysfunctional they are and how grossly they have managed the paperwork of the stadium non-NFL events. This is just one example. They solicited those letters to try to paint the picture that the stadium authority is dysfunctional and we are micromanaging. We knew this was coming. They knew by the time this article came out that this was going to happen this evening with respect to the revocation. They set it up just like they're about to set up other personal taxes. Brian and I have it already mentioned.
And I'd just like to say, as I predicted, they've already started tonight. And they're tweeting out ridiculous comments like Deanna's spiraling or something like that. I'm spiraling out there, okay? The press, you want to hear my quote? I'm spiraling because you are destroying this city. You are looting this city, the 49ers. It has nothing to do with the Rolling Stones. It has nothing to do with anything other than the fact that you have broken your promises to the voters. This is not about some ridiculous letter from some promoter that they asked to give them a letter so that they could attack us personally. This is all an attempt to deflect against us personally because they can't answer the questions. They can't handle the truth about their abysmal financial dealings in the stadium and their failure to meet the promises to the voters in Measure J.
Thank you. Thank you for that. Anything else, Councilmember Davis?
No, I just want, if you can please write that letter, and I would like a reasonable explanation as to why this is even happening.
Okay, so your reports, do we take any action on that? Just note and file or no action? Okay.
Take it as a referral.
Okay, thank you very much. That leads us to our adjournment. I have two adjournments this evening. Please adjourn. I'm asking the council and the Stadium Authority Board to please adjourn this meeting in memory of the following individuals. The first is Philip Tom, a longtime Santa Clara resident. Philip Tom was born in Honolulu, Hawaii on January 12, 1936. He served in the U.S. Navy from 1955 through 1959 and served in the U.S. Air Force from 1962 through 1968, where he served a year in Vietnam during the war. Mr. Tom was married in 1965 and moved to Santa Clara in 1969, where he raised his family and lived until his death. He was employed by several different airlines during the years following his time in the military. After working a year at Underwriters Laboratories, he joined Lockheed Missiles and Space Company and continued there until he retired in 1998 at the age of 62. Mr. Tom raised 4 children and spent much of his spare time woodworking and tinkering with cars. During his retirement, he helped raise his grandchildren, supported children around the world through various charities, and enjoyed spending time with his wife. Mr. Tom passed away on September 4th, 2019. Then I'd also like to ask the council that we adjourn in former Santa Clara Vice Mayor and Council Member James Viso. Mr. Viso was born in San Jose, California on February 14th, 1930. The son of the late Charles S. and Jessie D. Viso, he grew up in Santa Clara, California, and graduated from Lincoln High School. His first job was bagging groceries in his parents' Santa Clara store. Mr. Viso went on to own some of the region's most respected businesses, including James J. Viso Engineering, Inc., and El Camino Self-Storage. He played numerous key roles in the evolution of the Santa Clara community. Through the years, Mr. Viso served the City of Santa Clara as Vice Mayor and City Council member. He was active on the Santa Clara University Board of Fellows, and he was instrumental in the development of California's Great America theme park. Mr. Viso passed away on September 11, 2019. He was preceded in death by the love of his life, Vincie Viso, whom he married in 1949. And he is survived by his son and daughter-in-law, Charles, Chad, and Cherry Lou Viso of San Jose, his daughter Maggie Smith of Reno, Nevada, his daughter and son-in-law Jessica Viso Cole and Kurt Cole of Santa Clara, his daughter Vanessa Viso of Morgan Hill, son and daughter-in-law Joseph and Lisa Viso of San Jose, his son Jason Viso of Honolulu, Hawaii, 12 grandchildren and 10 great-grandchildren. Many of us knew Jim, and he was also instrumental in helping us get the road pattern back for the future downtown of Santa Clara, and we are still working closely with his family. He served with my father 50 years ago on the city council, and we will miss him. So, Teresa, do you have when his services, in case people would
for
want to
those
know?
who knew Jimmy Viso and might be interested in attending his services, the vigil service will be this Thursday, September 19th at 7 p.m. at Lima and Campagna Sunnyvale Mortuary, which is at 1315 Hollenbeck Avenue, and the funeral mass will be Friday, September 20th at 11 a.m. at St. Justin's, his longtime parish.
Thank you very much. Is there a motion to
Motion to
adjourn in both their memories?
Motion to adjourn.
Motion second to adjourn. Please register your vote. And that passes with those present. Meeting's adjourned. Thank you.